Now resuming, and I welcome to the table Minister Green, and I call ministers from the Office of the Inspector of the National Anti-Corruption Commission. Ms Furness, do you have an opening statement?
I do not, thank you, Senator.
We love to hear it. Thank you very much. We'll now proceed to questions. Senator Shoebridge.
Thanks, Inspector. Can I just note for the record the anxiety I have being stuck between the current and former chairs of this committee? It's causing me significant anxiety.
You know, you'd be pleased to know I'm a therapist, so I can talk to you about that
Okay, so if we can have a session at 10:15.
Better chair.
If we can have a session at 10:15, I'd appreciate it.
The risk is that we both know your tricks, Senator Shoebridge.
Yes, this is my concern. Inspector, thanks for your attendance tonight. How many complaints have you received since your commencement of operations?
I received 75 complaints in the last financial year and 50 in the first year, and I've received about 30 odd since.
You received a number of communications in relation to robo-debt. Are they in a separate category?
No, they're the 1,300 I haven't counted.
Okay, so 50 in the first year, 75 last year, 30 so far this year, and then another 1,300 in relation to robo-debt?
Yes, it's 30-ish in the first quarter, but since the 1st of October, or early in October, I've received another 50.
Oh, since 1 October, another 50? Are you able to categorise what the complaints are about? Have you gone through that process?
Most of the complaints I received in the first and second year concerned the decision by the Commission not to investigate a person's referral. That continues to be the main theme. What increased in the second year was complaints about the Commission not responding in a timely way to a referral. Yep. And that's either by way of update or by way of outcome. And in the second financial year, I had some complaints about the Commissioner and the engagement with Defence.
All right. And of course, your answers are all, we're putting robo-debt in a separate bucket for the purpose of these answers.
That's right.
Yep. And the complaints that you've had, there's been a surge of complaints since 1 October.
Yes.
What have they been in relation to?
They've followed on from the ABC media item that's been discussed earlier today.
Okay. Would you be able to give a breakdown of the complaints that relate to conflicts of interest, either actual or perceived, and other matters?
Well, the last 55 I've received have been about the ABC item, and they've been couched in different terms, but largely about a perceived conflict of interest or actual conflict of interest. It's been put in different terms in respect of the Commissioner's ongoing engagement with the IGADF, however that can be described. So
we'll just quickly deal with the robo-debt complaints. Those 1,300, had they all preceded your dealing with, were they all dealt with in your substantive response to the robo-debt? They were, however, they've continued to trickle in, if I can say, but the later ones are generally about the decision to engage the Honourable Mr Nettle, and then the decision to investigate and the time that has elapsed since. So I have had fewer than 100, more than several dozen in post-report. And have you, do you have a, dealing with the non-robo-debt complaints, dealing with the non-robo-debt complaints, do you have a time frame which you are looking at to resolve complaints within? Do you have a guide? Yes. Generally, I resolve complaints, by which I mean provide an outcome letter, to a person within about 2 or 3 weeks. And are there any outlier matters that have taken longer?
There are a number of outlier matters, and the reason they go beyond that include that I need more information from the person who's complained. I need information from the Commission, and then that may go backwards and forwards depending upon the nature of the complaint. So the outliers are where I need further information other than what's been provided to me with the original complaint.
Apart from the robo-debt matter, have there been any other complaints which have been substantiated or where you've taken action in response to the complaint?
As at the end of last financial year, the answer is no. But over the first quarter of this year and up to date, there are matters that are under active consideration, and I can't really say more than that.
Okay. Are you able to give a breakdown of the investigations that have been completed? And I'm more than happy, Inspector, if you want to provide some numbers on notice rather than try and pepper your mind for exact numbers now, but if you can.
Well, the term investigation is a term of art in the legislation. So an investigation is a corruption issue investigation or complaint investigation. So I've only done one of those, and that's robo-debt.
Okay.
All the other matters I've dealt with by way of correspondence with complainants and the Commission and outcome letters, none of which, as at to date, have ended in an investigation.
And would it be accurate to say that the complaints you'd received up to the end of last financial year, those had all, apart from the robo-debt complaints, they had all concluded?
No.
Okay, some of those are still ongoing?
Yes.
Yep. Was this the level of work you were expecting when you put your hand up for the job, Ms Vanessa?
No.
Yeah.
No, I thought it would be, there would be less work. I thought that it would centre around a decision not to investigate, because that's similar to my New South Wales hat. And that's certainly the case, that most of them are about that. But there have been a number of quite complex matters that tend to be increasing.
And in terms of your availability and your time, do you feel like you've got adequate time to deal with the matters that are on your plate?
Yes.
Yep. And in terms of the resources that you're getting to assist you, do you feel like you're getting adequate resources to assist you?
I am. What I did in relation to robo-debt and what I will do from time to time is engage someone to help me doing various specific tasks as needed, and I can easily accommodate that within my budget.
All right. Well, thank you very much, Inspector. It's very helpful.
Thank you, Senator.
Thanks.
Thank you, Senator Shoebridge, for being very efficient. We are now in a position to release you. Thank you very much for your time
Thank you.
this evening. And I now welcome the Australian Human Rights Commission. We'll take a short suspension while we welcome them to the table. We will now resume proceedings. We welcome the Australian Human Rights Commission. President, I understand you've got a very short opening statement that you would like to make.
Thanks, Chair.
Sorry, and before you do that, I'd like to notify that we are in a position to release the Federal Court of Australia as well. Thank you very much.
Thank you, Chair. I acknowledge Ngunnawal and Ngambri elders and ancestors, their culture and their ancient and unbroken connection to the country that we're meeting on tonight. Today marks 2 years since Hamas's terror attacks on Israel. Hamas and other armed groups killed over 1,200 people, injured thousands more, committed rape and sexual violence, and took around 250 people hostage. It was the largest loss of Jewish life on a single day since the Holocaust. Today's a day to acknowledge, remember and mourn those who died and suffered, and echo calls for the release of the remaining hostages. It's also a day to reaffirm our common humanity and commitment to human rights and the need to ensure peace and safety for all people. Since Hamas's brutal attacks 2 years ago and Israel's devastating and ongoing response, racism has surged in Australia with increasing anti-Semitism, anti-Arab racism, anti-Palestinian racism, Islamophobia and prejudice against Israeli Australians. We must address this racism, this hatred and this prejudice. This has been a major focus of the work of the Australian Human Rights Commission, including through the Commission's National Anti-Racism Framework, which sets out a roadmap for addressing and eliminating racism in Australia. We stand ready to work with government, the special envoys and the community to implement this roadmap to ensure racial and religious equality for all Australians. Senators, this estimates hearing is the last one for my colleague, the National Children's Commissioner, Anne Hollands. I want to acknowledge her important work over her term over the past 5 years. Thank you. Particularly around youth justice and child safety. Her Help Way Earlier report shows that targeted government action to promote children's rights and wellbeing is the most effective way to address and reduce offending. It shows how harsh punitive responses to offending by children are harmful and counterproductive. I thank Anne for all her work over her term. I also welcome the new Children's Commissioner, Deb Sabaris, who commences in mid-November. I'm confident she will be successful and make a big contribution to the Commission's work and the rights of children in Australia. Senate estimates is an important part of the democratic oversight by the Australian Parliament over the operations and expenditure of the Executive, and I look forward to the dialogue with this committee over this new parliamentary term. Thank you.
Chair, conscious of time, but I also have a statement in regards to Ms Hollands, if you don't mind. If I can make that now. Thank you. I would also like to thank the National Children's Commissioner, Ms Hollands, for her commitment to prioritising the safety and wellbeing of children throughout her term. I commend her work supporting the implementation of the National Strategy to prevent and respond to child sexual abuse, releasing Keeping Kids Safe and Well, Your Voices report, and leading the Supporting Quality Engagement with Children project to elevate and include the voices of children, young people and their families. During the COVID-19 pandemic, she also supported a better understanding of the pandemic's impacts on the mental health of our children. And she also developed Australia's first national child rights assessment tool and significant work to deliver the Help Way Earlier report to promote holistic consideration of child justice reform. The government acknowledges and thanks Ms Hollands for her service. Thank you.
Chair, would it be possible just in relation to Commissioner Hollands for myself to indicate on behalf of my colleagues, but I think probably for the whole committee.
I was going to do that.
But it was just on behalf of my colleagues, her incredible assistance not just to this committee in this work in estimates, but in a variety of other inquiries. And the quality of the work produced by the Children's Commissioner, and I especially want to highlight the Help Way Earlier report, the way that gave children a voice and hopefully will give them agency from our party and I think millions of Australians. Thank you very much for your work, Commissioner.
Thank you, Senator Shoebridge, and on behalf of the committee also thank you to Ms Hollands for all the incredible work, and I associate myself and the committee with the comments made by others already this evening. We'll proceed to questions now. We'll start with Deputy Chair, Senator Shoebridge.
Thank you very much, Chair. I have a few different issues to canvass tonight, but we'll start off with some questions to the President. President, I wanted to start with a question about the message that you have on your website marking 2 years since the 7th of October. And you make it very clear in that message that it's not the role of the Australian Human Rights Commission to determine on the evidence whether Israel's actions in Gaza amount to genocide. But in the very next sentence, you cite a whole range of people who have said that genocide is occurring. It wasn't really a discussion of the principles that were at play and what we know is a highly contested issue. Rather, having just said it's not the Commission's role to have a view on whether a genocide is occurring, you then, following that, select views that say that it is. Do you not think that you've already made a call when you've outlined that it wouldn't be appropriate for the AHRC to do so?
What we're doing there is being clear about our role in our legislation, and then being clear about the job of others, and particularly referencing the UN Independent Commission of Inquiry, whose job it is to look at human rights abuses in the occupied territories. And obviously recently they concluded on their assessment that genocide is occurring, and also referencing the fact that the International Court of Justice currently has a case before it brought by South Africa against Israel, and they will definitively determine whether genocide has occurred.
Do you accept, though, President, that an ordinary Australian reading this message on your website would be left with the impression that there is a genocide occurring, even though, again, you've specifically said it's not the Commission's role to determine that issue?
I think the words there, we've said many experts have concluded that genocide is occurring, and we've also said that many in the Australian community want this to be recognised as a genocide, and others in the Australian community oppose that position.
Okay. I also have some questions, I think for you, President, if not your Acting Chief Executive, while you're at the table, around your partnerships with security agencies. My understanding is that you have a long-standing partnership with the ADF to act as an independent advisor on cultural reform. Is that right? And if so, how long has that agreement been in place?
And it might be good to bring up the Sex Discrimination Commissioner, Anna Cody, who leads those
Oh,
partnerships.
apologies. I thought I'd be avoiding too much musical chairs. That's all right.
That's okay. So I think the question was about the length of the partnership with the Australian Defence Force.
Yes.
Thank you, Senator. The relationship with the Australian Defence Force has been since 2014.
2014. Is that a fee-for-service model?
It's each memorandum of understanding is for a particular amount, so it's not so much fee for service, but rather a relationship, a partnership that's entered into with particular terms.
Does the Commission receive any funds from the ADF to perform that role then?
It does.
It does, as per each MOU that you undertake. Do you have any other similar partnerships with other agencies to do this sort of work?
Yes, we also have a relationship with Australian Border Force as well as Australian Federal Police.
Okay. And would it be fair to say that your agreements with the AFP and, the AFP and the ABF are similar, MOU, you receive funds from agencies to undertake that role?
That's correct. Each has got slightly different terms, obviously.
And how long have the partnerships with the ABF and the AFP been going for?
So the ABF, from memory, is 2021 and AFP around 2022, or it might be vice versa.
Sure. Could you tell us how much those partnerships are worth per annum? That might be a little hard if you're going from MOU to MOU, but I'm just wondering if you have a breakdown of cost.
Thank you. So with Australian Defence Force, it's for the current year, it's 2.3 million. Australian Border Force, 2.3 million, and Australian Federal Police, 900,000.
I think those are 24, 25.
Yeah, 24, 25. Sorry.
That's a pretty significant amount, particularly in the case of those first two. So I'm interested in understanding, Commissioner, obviously the Commission has a role to play handling complaints when it comes to, the ADF is one example, the BF, the AFP. It is conceivable that any number of complaints could be made under the piece of legislation that you have custody of. How do we balance the fact that you are the regulator on one hand, but also providing advice to government agencies on what they should and shouldn't be doing? I'm just concerned that there's a bit of a blurring of roles if you're conciliating issues on one hand and then telling one party how to deal with them on the other.
We are very strong at maintaining our independence in our collaboration relationships with each of those three agencies or partners. We also have information barriers in place in relation to our conciliation and investigation function. So there is no information sharing between the complaints function and the defence or the other collaborations.
Okay. What processes do you have in place internally to ensure there's no information sharing?
As in any legal practice, so confidentiality of all complaint handling. There is a separate senior executive who's responsible for complaint handling and resolution, and the other section, so defence collaboration, AFP and Border Force, are physically separately located. There's a wall in terms of sharing of files, so no electronic file sharing. There is a clear delineation between the functions.
Okay. Have you ever received any complaints from anywhere, frankly, about the blurring of the lines of these two functions?
Not that I'm aware of.
Okay. And how does it work in terms of the positive duty? So on the one hand, you're being paid as an advisor to presumably assist these agencies adhere to their positive duty, but on the other hand, you're the regulator of that duty. Isn't that problematic?
So we only have received or entered into a new memorandum of understanding with Defence since we had the regulatory function of the positive duty. And again, we have a very clear information barrier between our positive duty regulatory function, and I can refer to the President to answer further on that. But the relationship is very clearly delineated within our memorandum of understanding with Defence, that we do not advise them around their compliance with positive duty.
Right. And you may not be able to tell me this, but would it be the longer term intention to mirror that provision across your other MOUs with government departments? Yeah, thank you. Chair, I'm being very efficient. I'll pass the call on now, but I do have more questions.
Excellent. Thank you very much. Senator Chamberlain. Senator O'Neill.
Thank you very much, Chair. I just want to ask a couple of questions about the prevalence and impact of sexual harassment in the Australian workplace. So, good timing. Thank you, Dr. Cody, for coming to the table. Just how critical is data to inform us of the state and response capacity to the prevalence and impact of sexual harassment in Australia?
Data is absolutely critical. We cannot know whether or not the measures that we are taking currently and also the functionality of the positive duty unless we have current and up-to-date data. Our most recent national survey was in 2022, which revealed that 1 in 3 women had experienced workplace sexual harassment, and that those numbers are even higher for particular groups of women, such as First Nations women, culturally, racially marginalised women, women with disability. So it is really essential, and that's one of the recommendations coming out of our most recent Speaking from Experience report, which was released at the end of June, and we are currently in discussions with Attorney General's Department as well as DSS, as well as the Office for Women about the funding of a survey for 2026.
Okay, so that was what I wanted to get a sense of. That it was recommendation 2 of the report, Respect at Work Sexual Harassment National Inquiry Report. 55 recommendations. Recommendation 2 states that the AHRC should conduct nationally representative survey into sexual harassment every 4 years. You've indicated that that is your intention, is that correct?
It is our intention if we receive funding to do so. We cannot run that survey unless we are funded to do that.
And has the AHRC already provisioned funding for the survey in its budget?
No, it does not.
So, given the answer to the first question, data is fundamental, why has the AHRC not provisioned that already within the budget that you've been allocated, knowing that the recommendation was for it to occur, the vital nature of data and the 4-yearly cycle that has been established for the collection of data? It's not like it was unforeseeable.
In the past, there has been an additional allocation of funding that is provided to the AHRC to conduct the survey. So that has been occurring for some years, and so it was an additional allocation of funding rather than to come out of the operating budget of the AHRC.
Okay, so to be clear at this point of time, you are intending to undertake another survey in 2026?
If we are funded to do so.
And if not?
Then we will be unable to do that.
Perhaps on notice, Chair, to move things along, could I just ask for an update on the progressing towards implementation of the 55 recommendations?
All of the recommendations have been implemented. The production of the Speaking from Experience report was the last of the recommendations. Okay. That was implemented in June of this year.
And how would you characterise the success of that implementation at this point, Dr. Cody?
I think workplace sexual harassment continues to be an issue within our workplaces. So there has been substantial progress in changes to Fair Work legislation, to the Sex Discrimination Act, funding of legal services to provide advice and representation to those experiencing workplace sexual harassment. So there has been progress. Whether it's sufficient? No, it's not sufficient because we still have a substantial problem with workplace sexual harassment.
And is there further work proposed by the AHRC to deal with what you know is occurring despite the implementation of the 55 recommendations?
So we have the Positive Duty Unit, which is part of that regulatory function, ensuring both education of employers and businesses, as well as inquiring into the lack of compliance with positive duty. And they also have an educative function, as well as my own advocacy and the sex discrimination team's advocacy around the importance of eradicating workplace sexual harassment.
And a failure to comply leads to what action by your body?
Do you want to take that?
A failure to comply with the positive duty, Senator?
Correct.
Yeah, so there would be two predominant legal consequences. One is an individual who experiences sexual harassment could lodge a complaint under the Sex Discrimination Act, which would be investigated and conciliated by the Commission, and if not resolved then, the person could take that to the federal court system. Separately, the new function that the Commission has is as the regulator of the positive duty, and so that's a regulatory function around education, engagement with employers, but also launching formal inquiries into compliance with the positive duty to eliminate sexual harassment, sex discrimination and other unlawful conduct that can lead to enforceable undertakings, compliance notices and the like.
So how many inquiries have you got running from complaints, and how many actions of enforcement have you on foot?
So we've got 4 inquiries, 4 formal inquiries currently on at the moment. I think we've received 72 reports around positive duty non-compliance. We've had 35 voluntary engagements with employers covering around 120,000 employees.
So perhaps you could provide some more details on notice with regard to that action. Sure. That would be most welcome. Thank you,
Yep.
Chair.
Thank you very much, Senator O'Neill. Senator Faruqi.
Thank you very much, Chair. Good evening, everyone. I have some questions for the Human Rights Commissioner and the Race Discrimination Commissioner. Thank you. I might start with the Human Rights Commissioner. In early September, you attended and spoke at the Combat Anti-Semitism Movement, Australia's so-called Mayor's Summit against anti-Semitism. Is that correct?
Yes, Senator.
Before you attended the summit, were you made aware that a known neo-Nazi was attending the event, and that the summit was organized and funded by a group with very strong ties to Israeli military, the same military that is committing a genocide in Gaza at the moment, and the Zionist lobbyists, as well as far-right politicians in the US, like Congressman Randy Fine, who has called for the streets of Gaza to overflow with blood. He has tweeted, "Gaza must be destroyed," and recently told Gazans to just starve. Were you aware that these people are organisers?
Well, Senator, I was aware that there was a conference organised within Australia. It was an Australian Mayor's Summit against anti-Semitism that was designed to confront and address and provide practical options for addressing the surge in anti-Semitism in Australia. In terms of your initial assertion that, or question about was I aware that a neo-Nazi attended the summit, in fact, I'm aware that a former neo-Nazi did attend the summit, that being Jeff Shep, who has since renounced his former views and dedicated his life to countering hate and extremism. And I'm aware that he attended and spoke on a panel together with Muhsin Sheikh, a former jihadist extremist who's now turned Canadian counterintelligence operative, who both spoke about the importance of disavowing hatred, working to counter extremism and to help de-radicalise individuals. And again, in my view, attending a conference to hear from people who are engaging in countering hatred and disavowing extremism is something that can help us in Australia understand how better to do that. And attending a conference that broadly addresses anti-Semitism and that had either in attendance or video messages of support from the Deputy Prime Minister, the Minister for Local Government, the Leader of the Opposition, the Queensland Premier and the Queensland Leader of the Opposition, as well as a former Prime Minister of this country, Julia Gillard. It's a conference that had a diversity of perspectives available, with the one unifying feature that everyone attending is firm in their commitment about the importance of addressing anti-Semitism in Australia.
That wasn't really the purpose of the summit, Commissioner. The key purpose of the summit was to encourage local councils to treat criticism of Israel as anti-Semitism. You know that as well as I do, because I have seen what came out of the summit, and you have conveniently dodged my question of did you know that this summit, the organisers of this summit, who they are, and how deep ties they have with the Israeli military committing a genocide in Gaza right at this moment, far-right US politicians. So how is it appropriate for a human rights commissioner of this country to attend and speak at a summit with such deep ties to a military committing genocide?
Well, Senator, having attended the summit, I absolutely disagree with the premise of your question. It was a summit designed to counter anti-Semitism. That was my experience at the summit. That was what was spoken about at the summit. And I think it is entirely appropriate for an Australian Human Rights Commissioner to be engaged directly in efforts to counter the surge in anti-Semitism that we've seen in Australia, and more broadly the surge in hatred and violence that we've seen in Australia. And the fact that we are having this conversation on the second anniversary of October the 7th, and the criticism that my attendance at the summit has generated only serves to reinforce to me the importance of having such a summit and the need for such a summit in Australia in terms of addressing what is a critical human rights issue.
The organiser of the summit, Combat Anti-Semitism Movement's CEO, Sasha Rotman, has stated that anti-Zionism is anti-Semitism. Do you believe that any criticism of Israel equates to anti-Semitism?
No, Senator, and I in fact heard the Australian Special Envoy against anti-Semitism directly state at the summit precisely the opposite, that criticism of Israel in and of itself is not anti-Semitism. However, in certain contexts, it can veer into anti-Semitic sentiment. In terms of the conference itself, again, I would reiterate, my involvement in the conference was to attend a national conference designed to confront and condemn anti-Semitism, and my specific involvement was to be part of a panel focused on securing communities, law enforcement and digital threats, which draws on the work that I've done at the Commission in terms of human rights in digital spaces and leading work against online hatred.
Yeah, of course, Commissioner, we should all condemn anti-Semitism and all sorts of racism. But the summit was really pushing for the IHRA definition of anti-Semitism to be adopted, which has so many criticisms because it does conflate anti-Semitism with the criticism of Israel. So you cannot deny that was the purpose. And what came out of the summit was a CAM report, which I found very alarming, a CAM report that catalogues supposed anti-Semitic symbols. I'm sure you have seen that report as well. The list includes the symbol of a watermelon, as well as a kafir and a Palestinian flag. Now, do you think that a symbol of a watermelon or this kafir is anti-Semitic?
Well, Senator, there are a number of things arising out of your question. The first is, again, I'd reject the premise that the purpose of the summit was to address or endorse the IRA definition. Having attended the summit, it was a summit designed to address and confront and combat anti-Semitism. In relation to the document that you referred to and the reference to the watermelon, I have seen that document. Again, I didn't see that document until post the summit, but what the document doesn't suggest is that symbols like a watermelon are inherently anti-Semitic. What it does do is highlight the novel and historically repurposed symbols that have been co-opted and disseminated by some in the aftermath of the 7th of October as anti-Semitic symbols. It's not suggesting a watermelon in all contexts is anti-Semitic. That would be absurd, but it is suggesting that some symbols can have different meanings depending on the context in which they're used.
I think what you are saying, suggesting right now, Commissioner, is a bit absurd. To even suggest that a watermelon symbol or a kafir could be anti-Semitic, it sounds very ridiculous to me. But I will move on. A couple of other questions or another topic. I know that you're interested in the emergency response to climate change, but in general, climate change as an issue of human rights. Mm-hmm. In July, the International Court of Justice issued an advisory opinion on the obligations of states in respect to climate change. And the court stated that climate change poses an existential threat to a wide range of human rights, including the rights to life, health, food, water, and housing. Is the Human Rights Commission planning to respond to such a significant development in international human rights law?
Well, I might, Senator, if I may, hand to the President, who's been leading the work of the Commission in that respect.
Thanks for the question. The answer is yes. So not to respond directly to the ICJ advisory opinion, but the Commission has work that is close to being published around the impact of climate change on human rights and how governments around the world need to respond. But obviously our particular focus is on the Australian government.
Okay, thank you. And I might come back with another question, but I have a few questions for the Race Discrimination Commissioner. Commissioner, it's been almost a year since you released the National Anti-Racism Framework, which of course includes 63 very good recommendations to the government. And you yourself has described that we need to combat the visceral increase in racism in this country. In a recent Guardian podcast, you said that you weren't sure whether the government was committed to combating racism in Australia. And you spoke of your disappointment that the government has yet not committed to any of the recommendations in the NAF, which has been sitting on a shelf for a year. So I guess my question to you is, have you received anything from the government since then that has indicated when they'll respond?
No. I should clarify, in that podcast I said that the fact that the government had funded the creation of the framework and the National Anti-Racism Strategy indicated that they were taking some action against racism. But yes, I did say as well, however, what's really needed is funding of the National Anti-Racism Task Force. And as of now, I'm not sure what their position is, and it hasn't been indicated to me.
What is the cost, Commissioner, of delaying action on racism as recommended by the framework?
I would say that we need action now. The longer it takes to take a coordinated whole of government, whole of society approach to tackling racism, the more the scourge of racism diminishes people's lives. And in the case of racism health, it costs lives. In the justice system, it leads to incarceration and deaths in custody. There is a huge cost in terms of people's lives, in terms of society, in terms of a financial cost. So it is a pressing issue.
Commissioner, you also must have seen with a lot of concern the recent, I guess, far right being emboldened with their so-called March for Australia, which in Naarm ended up with a violent attack on Camp Sovereign and First Nations people. And, you know, the marches were attended and addressed by neo-Nazis and far-right extremists. The Prime Minister responded by saying that good people had attended rallies. We know that politicians over the years have dog-whistled as well, with Senator Jacinta Price making a number of comments about Indian migrants. Just recently, Andrew Hastie said that Australians were starting to feel like strangers in their own country. We've seen migrants and international students being blamed for the housing crisis. How does this messaging around people of colour and First Nations people help embolden the far right, and does it?
When you say that, well, so Senator, the messaging you referred to is messaging on migration, I assume?
Yes,
yeah.
on people of colour, yeah.
It's clearly migration is a policy issue that can and should be debated. The issue is when certain groups are dehumanised or isolated. As, for example, prior to that particular march that you just referred to, there were posters and propaganda materials that targeted the Indian community, which caused enormous distress to many in the Indian community. It's that dehumanisation and isolation that is highly problematic, and it's racist in its nature, and that's what causes the problems when simplistic solutions that dehumanise groups rather than informed, sensible, well-thought-out discussions about complicated issues.
Commissioner, you have also spoken about what's happening in Gaza, dehumanizing the people of Gaza, which in turn dehumanizes all Palestinian people, Arab people, and Muslims who live here and around the world. The Labour government, as of yet, has refused to use the word genocide to describe Israel's carnage and massacre, even when the UN and numerous other internationally respected organizations and scholars have described it as a genocide. Can I ask you if you agree with the UN and the scholars that what is happening in Gaza is a genocide?
Senator, that's a complex and loaded question in some senses. I was asked this recently, and I'll say the same thing I said then. It's not for me, as Race Commissioner, to make a determination under international law of such significance, but you don't need to make that determination to recognise the immense suffering that is occurring in Palestine. And if you don't recognise the suffering that's occurring there, you dehumanise people, and by extension, you dehumanise those that identify with them here. And that's what we need to stop. We have to recognise the humanity or the inhumanity of what's occurring everywhere. Suffering, not recognising suffering anywhere, is a dehumanising process which then extends to those who feel that suffering here.
Not taking action or strong action to stop the genocide, does that dehumanise people as well?
I would say that everyone should be taking all efforts possible to end conflict and to end suffering.
Thank you, Senator.
Thank you.
Thank you very much. Senator Roberts.
Thank you.
Is that me, Chair?
Yes.
Thank you. Thank you, Chair. Thank you for appearing today. Mr. Sivaraman, is that how you pronounce it?
Sivaraman.
Sivaraman, thank you. As Australia's Race Commissioner, the Discrimination Commissioner, you say the bile of racism, your words, is spilling out into the public forum in many political debates. Do you stand by that comment?
Yes.
Is questioning the migration intake numbers racist?
In of itself, it doesn't have to be. No, it's a question of what's associated with that and whether certain groups get targeted.
Okay, thank you. Mr. Sivaraman, there are currently 4 million people in this country, our country, who aren't Australian citizens, are not Australian citizens, taking up beds while Australians are homeless, record homelessness, after years of unprecedented levels of mass migration. We have been at record numbers for multiple years in a row. That's not saying anything disparaging about those people who have arrived. That's just a fact. It is just a mathematical fact that if we continue to accept arrivals at the rate we are, our schools, hospitals, dams, transport and housing are going to become even more overwhelmed than they are. That's a fact. Is anyone who acknowledges that fact a racist?
Senator, I think the first issue is to simply connect in a very linear way migration to the various problems that you've described would not be accurate. The problems that you've...
What is inaccurate about it, Mr. Sivaram?
The problems that you've alluded to, like housing, the cost of living, are complicated problems with many different sources. Migration is one of many different factors that may or may not contribute to those issues. Directly linking them is something that I wouldn't agree with, and it's that simplification that often then leads to the scapegoating of migrants, Senator, and I think that can be problematic.
Could you tell me how I'm scapegoating migrants, and can you tell me how, when I am one, and can you tell me how it's simplifying the issue?
Because it is a simplification of an issue if you directly say that there is only one cause for the significant problems that you've
I didn't say
outlined.
there was only one cause. It's the significant factor.
Even that in itself is a simplification, Senator. There could be any number of factors that contribute to those issues.
We know for a fact that we've got record homelessness, and the government is bringing in record numbers of people year after year after year. They haven't got anywhere to go, Mr. Sivaram. We even see now migrants coming in here, being given housing, and then being turfed out when the next wave of migrants comes. Is that fair to the migrants?
Again, Senator, I'm not sure if I can take it further. The issues you raise in terms of homelessness, it's obviously a serious and significant issue. I think simply pointing to migration or migrants as the problem or the cause of that issue, I think is overly simplistic.
What about the skills misalignment between the skills we need in this country for people to get straight to work and bringing in people without those skills and not being able to find work? Is that dehumanising to the migrants? Is it dehumanising to the people here?
Senator, I'm glad you raised that issue. I think there is a real problem with the failure to recognise skills and experience and qualifications of migrants, which often leads to people being underutilised and dampening their productivity in the workplace. And I know that Settlement Services International are running a campaign now called Activate Skills Australia, because we do want to fully utilise the skills of people that come here, of migrants that come here, so that they can contribute to our workforce, and that's a really important issue.
But if they don't have the skills, for example, construction in the first place, with the government bringing in supposedly construction workers with skills in construction, but only 0.6% being actually having those skills and experience, how are they going to build houses for the other 99.4%?
I think, Senator, I'm not sure where the statistics you've quoted, I'm unaware of them, so I can't speak to those statistics specifically, but in a general sense, there is a lot of research and data that shows that we have failed to recognise the skills and qualifications of migrants, and that is a significant detriment to the Australian economy.
Thank you. My final question before moving on to Dr. Cody. I understand in your role as Race Discrimination Commissioner, you are being paid $398,450 per annum, almost $400,000, plus 15.4% super. Are those pay figures correct?
I think that they would be, yes. I'd have to check the Remuneration Tribunal determination, yeah.
Thank you. I'd now like to go to Dr. Cody and the intervention in Giggle versus Tickle, please. Thank you for appearing, Dr. Cody. What are you arguing in your... This is the case of someone, Giggle versus Tickle, who was born a biological male, being stopped from joining a women-only app. What are you arguing in your intervention? How much are you being paid by the taxpayers to go in and bat for biological, born and developed men to be allowed into women's spaces?
Thank you, Senator. The role that we have within the case Giggle and Tickle is intervention, so amicus curiae, so helping the court to understand the interpretation of the Sex Discrimination Act and the amendments from 2013. Also how the Convention for the Elimination of All Forms of Discrimination Against Women applies, whether or not there are special measures and the understanding of Section 5 and Section 7 of the Sex Discrimination Act. So we were given leave by the court to assist them to understand those issues and also the constitutionality of the Sex Discrimination Act. In terms of the cost, we have two counsel who were briefed. one who both agreed to appear on a capped fee basis, so that's a reduced fee. So one was paid $13,000 and the other one was paid $10,000.
Thank you. What I actually asked Dr. Cody was, how much are you paid by the taxpayers to go in and bat for biological born and developed men?
So my salary is similar to that you mentioned for Commissioner Sivaraman.
About $400,000 per year plus 15.4% super.
Correct.
Thank you. If a woman took a case... Oh, just so that I can be clear, your position is that the law means a biological man who identifies as a transgender woman can enter a female-only space?
So I would question whether or not Roxanne Tickle is not a man. She is a trans woman, and so she has gone through various processes and has transitioned, and she's a trans woman. So she has access, or sought access, was provided access to the Giggle for Girls app, and then was taken off the access to Giggle for Girls app.
So what sort of chromosomes does she have? XX or XY?
I can't answer that, Senator.
You can't?
No, I can't answer that.
Wow. If a woman took a case to court today trying to stop a person with a penis... Well, let's come back to that. Can someone who was born on XY chromosomes change to XX chromosomes? A male change to female?
I don't believe so, but I'm not a scientist. There are many variations of chromosomes. There are hormonal variations, there's chromosomal variations, there's genitalia variations, there's a lot of variations which are along a spectrum.
Would you agree that a piece of legislation can't change a person's sex? If born a man, they are a man. If they're born with XY chromosomes, they're a man and they stay a man?
No, I would not agree.
You don't agree?
No.
If a woman took a case to court today, Dr. Cody, trying to stop a person with a penis who identified as a female going into a women's bathroom, which side would you be arguing for if you were there as a friend of the court?
Could you repeat that,
Sure.
Senator?
If a woman took a case to court today, trying to stop a person with a penis who identified as a female going into a woman's bathroom, which side would you be arguing for if you were the friend of the court?
I would need to know more facts, Senator. I can't make a judgment on that in particular.
So come back to your previous answer. You talked
Senator?
about XX, XY, you didn't really know the answer. How can you make a decision on sex?
The issue that I'm saying around me not being able to identify whether someone has XX or XY is because I haven't tested them. I'm not a scientist. That's not my area of expertise.
If a person was born male, that's XY. Born
Not
female,
always.
that's XX.
Not always, Senator.
No?
No.
Can you give me an example when not?
Because there are also people who have innate variations of sex characteristics, and so they may be identified as male at birth, but in fact then later find out that they have XY chromosomes or XX chromosomes. So it is more complex than just XX being female and XY being male.
I'll agree with that, but it's a very, very tiny proportion of the population. But someone who was born a man, a boy, as XY chromosomes cannot change to XX. Is that correct?
If they are born, if their chromosomes are XY, then their chromosomes, I don't believe they can change. But as I repeat, I'm not a scientist, so I haven't studied whether or not
so you're
they
not
can
a scientist.
change it.
How do you know which side to take in a court case?
I'm not taking a side within a court case. Our role is as amicus, so that is to provide clarification, help to the court in understanding the legal issues that are in dispute.
So how can you clarify if you don't understand?
I understand the law. What I don't understand is the science around the XX, XY, unless the evidence is before the court. So my role is to assist the court with understanding the legal argument.
On my reading of what you've said in Giggle versus Tickle, The position on biological males and female spaces seems pretty clear at the Human Rights Commission. Could you explain
What would you like me to explain, sorry, Senator?
what your position is?
On which issue?
The position on biological males in female spaces. Could you please explain the Human Rights Commission, your position on that?
What do you mean by biological males, Senator?
Someone born as a male, XY chromosomes.
So if they are a man, and depending on which space they are wanting to enter, then and why that space has been created, if it's a special measure, for example, for ensuring equality of women, then there may be good reason to exclude men from that space.
What would be some of the reasons?
For safety reasons, for example.
What sort of safety reasons?
Potentially at a domestic violence refuge, there may be a reason why, certainly there is a reason why men would be excluded from a domestic violence refuge for women.
Female prison?
In female prisons, then also it's made for women, and therefore men would be excluded from women's prison.
Okay, thank you. My next set of questions, only short, goes to immigration. Who wants to answer that? Maybe both of you. Okay, I should be able to do it. Depends on their answers. Thank you for appearing. I understand the Human Rights Commission takes a much more active involvement in immigration cases than many others. Would that be a fair assessment, as in it's probably the area that takes up the most of your time in terms of court involvement?
There's different functions of the Commission, Senator. So
I understand.
if you're looking at complaints about discrimination, disability is the accounts for the most common area complained about, disability discrimination.
The Department of Home Affairs has published data indicating that around 100,000 people are in the country who have exhausted their appeal options and are now unlawfully in Australia. Are you able to give me a sense of how many of those court cases the Commission was involved in?
Zero, I think. So if you're talking about the function that we have to assist a court around interpreting the law, that is a very tiny number of cases that we do. I think it was like 1 or 2 a year. And so the last, and I think the High Court case in NZYQ was the last one that we intervened in.
There are still 27,000 cases in progress for a final decision. Are you aware of how many of these cases you have intervened in or acted as a friend of the court?
Probably zero.
Okay. How much does the Australian Human Rights Commission expend on immigration matters a year, and how many people are employed in that section?
We can take that on notice, but to be clear, the matters you're talking about, we have no role in those court cases at all. It's only where there is a superior court case, like the High Court of Australia is ruling on a important area of law, where we might intervene in that case to provide assistance to the court.
Almost done. Second last question. When trying to talk about the human rights abuses of the COVID response, I was constantly told, well, human rights are not absolute. I assume the same thing applies to immigration. Is that your position?
If you're looking, it depends which right you're talking about. If you look at a right like torture, that is an absolute right. But if you look at rights like right to, freedom of expression, for example, then that can be subject to reasonable limits.
Last question. At some point, the right of someone coming here from another country will clash with an Australian's right of enjoyment to life, to access healthcare, to access housing, to access education. Do you ever consider that, or do you just go all the way with the rights of people coming into this country and trying to stay illegally, whatever the consequences on the people already here?
Senator, could I perhaps answer that in this way, and noting again that we do have different functions around immigration. The work that I lead is around particularly inspection of immigration detention facilities and that broader work around immigration detention. And if I can point you to the last few immigration detention reports that the Commission has done, we've been very clear about the fact that there does need to be a balancing of rights, and that our reports are designed to not only consider the human rights of detainees, but the broader human rights of staff working at facilities, and also the broader human rights of the Australian community. And so when you talk about something like considering immigration, of course we start from the position, and this can be seen in a number of our statements, that every nation has a right to control its borders. The way it does that matters, and the way it balances out different human rights matters. And that's the position the Human Rights Commission has consistently expressed, and then delves in our various reports to how those rights can best be balanced within the confines of the human rights framework.
Thank you. Can I just ask a little thing that's just come to my mind? Politically, racism or accusations of racism are used very strongly by some politicians in this country, and I would say dishonestly. The fact that they use those terms to try and discredit someone, doesn't that indicate that the Australian population does not condone racism, and that as a whole, the Australian population, regardless of skin colour, race, religion, ethnicity, abhors racism? Most Australians detest racism, look down on it?
I think that the reality is that racism remains a significant issue. We see it consistently. We've seen it in our consultations. We see it in the complaints filed with the Commission, and I've had it expressed to me, as was found in the consultations that led to the creation of the National Anti-Racism Framework. So for us to progress as a society, the best way to do that is to be honest and to recognise the problems we have and then courageously take them on.
Well, thank you for that. Wouldn't it still apply, though, that the vast majority of Australians detest racism, and that says that the vast majority of Australians are not racist? That doesn't mean we should condone it anywhere. I'm not saying that at all. But I simply want to acknowledge that Australians are generally not racist.
We have to think about racism as not just as an interpersonal issue, Senator, but also about whether our institutions and our systems disadvantage people based on race. And that's the type of racism that we need to really eradicate, so that people can bring their whole selves into, whether it be workplaces, schools, sporting facilities, whatever it might be, and simply be or thrive. Once we can do that, then I think that that's how we'll progress as a society.
Thank you, Chair.
Thank you, Senator Roberts. Senator Chandler.
Thank you very much, Chair. And in the interest of time, I'm going to seek to get through as many of my questions as I can in the next section, but it might be a little bit of musical chairs at the table. My first set of questions is to the Sex Discrimination Commissioner. Commissioner, I wanted to ask about your speech to the National Press Club last month. You said in response to a question about the protection of women's rights under CEDAW that we are not one version of woman. Now, last I checked, a woman is an adult human female with XX chromosomes. So what did you mean when you said we are not one version of woman?
That there is a great diversity in who we are as women, so that includes culturally, racially marginalised women, First Nations women, women with disability, lesbians, trans women, non-binary. There are a range of people who identify as women who are women.
Did you mean that biological males can be women?
Men. So I think that we have different language that perhaps you're using than I would use. So I don't understand the term biological men.
Right. This might be a short tranche of questions then. Commissioner, does the Sex Discrimination Act protect the rights of women based on their sex?
Yes, it does.
How?
So the Sex Discrimination Act makes it unlawful to treat someone less favourably on the basis of their sex. So, for example, not giving someone a job because they are a woman or not giving them a promotion because they are a woman, then that would be against the law under the Sex Discrimination Act.
And just so I'm abundantly clear, you're saying that the Sex Discrimination Act does protect the rights of biological females based on their sex?
So again, I'll change the language. It protects women from discrimination.
But it doesn't protect biological females, is
it
what you're saying.
does not use the language of biological female. It uses man and woman.
That's convenient. Commissioner, does the Sex Discrimination Act protect the provision of women's single-sex spaces and services? Let me rephrase that question, given what you've just said. Does the Sex Discrimination Act protect the provision of female single-sex spaces and services?
So it is, under the Sex Discrimination Act, there can be special measures if they are to achieve equality, substantive equality. So, for example, a program to address the lack of women carpenters that was provided only to women apprentices, that would be considered a special measure. So it's not providing the same treatment to men who are training to be carpenters, but it's providing a measure to try and improve equality for women who are wanting to be carpenters.
What if it were provided to biological females who wanted to be carpenters?
So it doesn't, the Sex Discrimination Act doesn't use that language. It uses the language of man and woman.
No wonder Australian women are disappointed. Commissioner, you'd be familiar with the Victorian case of a male pedophile being housed in a women's prison. It's been in the media in the last week. For the purposes of the Sex Discrimination Act, do you consider that this man, who is a child sex offender, is a woman?
The Sex Discrimination Act includes trans women within it. So the person who I believe you're referring to is a trans woman.
Right. That was very revealing. My next tranche of questions are to the Race Discrimination Commissioner. Commissioner, I want to table some tweets that have appeared and that they seem to be made by you. I might pass them to the Chair and the Secretariat because I think it would be useful for you to have a look at them before answering these questions.
Is it just one for each?
Yeah, just, sorry, multiple copies. Mm-hmm.
I'll table it.
And a copy could be provided to the Commissioner so that he could respond to questions. That would be useful.
Could I have a copy?
Yes,
Yeah,
yes,
it's
we're doing
it's
that.
being circulated, yeah.
Indeed.
Thank you.
10 years ago.
Commissioner, did you write these tweets?
I'll just have a look.
Thank you.
So they appear to be under my handle. I think the first one is 12 years ago, so I can't remember writing it. Second one is 8 years ago. It seems to be actually just a tweet about an article. And then the next one is 10 years ago. Yeah, I probably did. I can't remember because it's so long ago.
That's all they've got to with you on 12 years of tweeting.
Well, Commissioner, could you perhaps look at those tweets and try and jog your memory? I'm interested to know, I mean, there are some pretty interesting views that are being promoted in those tweets. You know, one of them was sharing a newspaper article about the Lindt Cafe siege. stating that the government's deterrent strategy had a logic strikingly close to that of Paris or Martin Place, violently attack the few to intimidate many. I'd be very interested in knowing whether you were still associate with that view.
I'm sorry, could you, I couldn't actually hear you. Could you repeat that question?
So the article, one of the articles that is linked in those tweets is a Brisbane Times article following the Lint Cafe siege, in which this article compared the previous government's migration policies to the actions of the terrorists responsible for that siege. And I just think it was interesting, if you shared that article, to know which one of the
Senator,
former...
I don't know what was in the article. This is 8 years ago. You'd have to show me the full article for me to answer that question.
Okay.
Or more than 8 years ago. I'm not even sure which tweet you're referring to.
Okay. In December last year, the Australian newspaper reported, Commissioner, that you wrote to the CEO of the Commission about your proposed engagements with Jewish groups. Are you familiar with that reporting from Yoni Bashan?
You'd have to be more specific.
Again, I have some copies to table for
but
your assistance and the assistance of the committee.
Asked about this at a different Senate inquiry already.
What was that, sorry, Commissioner?
I think I've been asked about this in a different Senate inquiry, so I think I know what you're referring to.
Okay. We might, thank you, and we might progress. Now, that report outlined that you'd contacted the CEO saying, and I quote, when inevitable questions come up in estimates, I'll be able to say I met with Jewish communities as a priority to hear their concerns on anti-Semitism. On one read, that comes across as like the Race Commissioner thinks that meeting with Jewish groups is just a tick-a-box exercise that you do so you can say you've done it at estimates. Would that be right?
That's not correct, Senator. I've had probably 30 meetings across my year and a half as Race Discrimination Commissioner with a variety of Jewish organisations, Jewish community representatives, Jewish community leaders, rabbis, and I'm enormously grateful for those people giving up their time to me. Sometimes I've heard really difficult stories of people who are the descendants of Holocaust survivors who've shared their pain and trauma with me, particularly about anti-Semitism they've experienced more recently. I've reflected that in articles I've written, in forwards to documents, and for me, I'm just very grateful that that community has given me the chance to engage with them, and I'll continue doing that.
Okay, well, I'm glad Estimates has provided you with the opportunity to put that on the record, Commissioner. Commissioner, apologies. In April this year, the following quote was widely attributed to you. Australia Day is Invasion Day for our First Nations brothers and sisters and is a day of mourning in many ways and not a day to be celebrated. And to not acknowledge that just compounds racism. Do you still hold that view?
I still hold the view that Australia Day is a day of mourning. The one thing I would change is I wouldn't say our brothers and sisters. That was a proprietary term that I shouldn't have used. So I would say for First Peoples, it is certainly a day of mourning for some First Peoples, and that should be acknowledged.
You don't think we should celebrate Australia Day?
No, I said it's a day, we should acknowledge the mourning for some people. That's what I said.
You also said, I think, that it's a day not to be celebrated.
For some First Peoples.
I'm not entirely sure that was abundantly clear on the quote. I'd advise you choose your words a bit differently next time. I mean, even a Labor Premier, Chris Minns, I think, has said that that's a pretty bonkers view. Do you consider your views within the context of what other people on the political left might be saying?
It doesn't really matter to me what people on a political spectrum think. For me, what is important is truth-telling about our history, truth-telling about the treatment of First Peoples, including the incredible mistreatment of First Peoples, and that the failure to acknowledge that continues and contributes to ongoing harm. And I think that for us to actually be better as a society and to come together, we have to walk side by side with First Peoples. They've extended their hand graciously to us, and we should take it in truth-telling.
Do you believe Australia Day is Invasion Day?
I think that it is a day that is seen as Invasion Day for some First Peoples, yes.
Okay, I have some questions around the National Anti-Racism Framework. That document calls for commitments that include acknowledgement of the systemic and structural nature of racism. The explainer on 5 common myths and misconceptions about racism that bears the AHRC logo and is available on the AHRC website explicitly says that we all live and participate in a racist system. Commissioner, do you think Australia is a racist country?
I think that racism significantly affects systems and institutions in Australia, and that's something that we need to combat to make our society better for everyone.
President, do you think Australia is a racist country?
I think if you look at the founding of Australia, it was founded by colonisation, where the rights of First Peoples were blatantly ignored, and we still haven't come to terms with that fundamental injustice.
Commissioner, we've heard that Australian taxpayers are paying you a considerable salary at this estimates. Are those Australian taxpayers racists?
Senator, I don't know if that's a helpful question. I think what taxpayers would want to see, like all Australians, is a society where everyone can be themselves, can flourish and can thrive. To get to that point, we need to name racism, we need to deal with it in a whole of government, whole of society approach, which is what we've called for in the National Anti-Racism Framework. So I think the thing to remember is that what we're advocating for with that framework is a society where systems and institutions are there for everyone.
That same explainer for the National Anti-Racism Framework explicitly says it is a myth that white people can experience racism. Do you agree with that statement?
I think that it's important to look at that explainer as a whole, not just taking one sentence out. But the important thing to note is that racism is rarely about any biological construct or the colour. It can be about the colour of someone's skin, but it is about the way in which power might be wielded by one person over another. Ta-Nehisi Coates, the African-American writer, said that race is the child, racism is the father. It's often created as a means of oppression, and in this country, in Australia, it has tended to be towards people who are not white. That's the important thing to recognise.
So you do think Australia is a racist country?
I didn't say that. I said that racism exists in Australia.
It's quite common in human rights circles to describe Israel as white, settler and colonialist. I know the UN Special Rapporteur Francesca Albanese has, for example, done this. Do you share that view, that Israel is an example of a white settler colonialist power?
I don't have a view on that aspect of Israel. It's not relevant to my portfolio. As I've said previously, what's important to recognise is the suffering that is incurred, and to failure to recognise suffering anywhere leads to dehumanisation here.
Okay. Thank you, Commissioner.
Thank you, Senator Chandler. Senator Shoebridge.
Thanks, Chair. Thanks all for your attendance. I have some questions to Commissioner Finlay. Commissioner, I might start first with the 2 inspection reports that you completed last year. The first was to the first inspection report was about Yunga Hill Immigration Detention Centre. I think you did that in April of last year, and the second was a broader one in women in immigration detention in December, I think, of last year.
Relating to women in detention?
Yes. Have you had any follow-up inspections of either of those facilities since those reports?
We haven't had any follow-up inspections in relation to either of those facilities specifically. I can confirm, Senator, that we are currently considering whether our next inspection should in fact be a follow-up inspection. But I would also note that in relation to both of those facilities, we do have regular communications with the department and have engaged specifically in following up on those recommendations to try and ascertain progress.
Well, why don't we deal with Yonge Hill first of all?
Sure.
I mean, it's an increasingly notorious centre with conditions that are, you know, I think your report fairly identifies as incredibly brutal. What, if any, changes are you aware have been implemented in Yonge Hill since your report?
Well, we're aware that there have been significant changes across the board in terms of the immigration detention network, particularly relating to the transition of service providers. We're trying to ascertain further information in terms of what that means in relation to the implementation of specific recommendations. I can say in relation to Yonge Hill, one of the changes that I'm aware of is a change in terms of infrastructure and facilities. But again, it's an ongoing process in terms of wanting to see those recommendations implemented in full.
Well, there's a new private global provider undertaking the contract for immigration detention. Do you understand that that has in any way improved the human rights outcomes at Yonge Hill?
Oh, Senator, we have a number of concerns across the immigration detention network in terms of existing human rights issues that relate both to before the new service providers and now post, acknowledging also that, as you would understand, this is a complex area where there can be examples of positive practice and improvements at the same time as there are still serious, significant concerns in place.
Well, perhaps rather than spend a prolonged period of time working through each of these reports, could you provide or notice what, if any, changes you're aware of being implemented in Yonge Hill Immigration Detention Centre since your report in April 2024 that have been advised to you?
I might take that on notice if I can, Senator.
And in relation to the Women in Immigration Detention report, how many facilities did you visit?
We visited 3 facilities, Senator.
Which were?
Which were the facilities in Melbourne, Sydney and Perth.
All right. And again, I think you found the conditions in which women in immigration detention were held were often sometimes dehumanising and brutal.
And I think the really important finding, Senator, was we had both systemic findings that stretched across the treatment of women generally, but also the report detailed specific findings in relation to each centre. And again, I do want to emphasise, whilst our overarching findings did highlight very significant concerns, we don't want to detract from the fact there were also examples of some positive changes that had occurred, and it is in that sense a situation where we would like to see the full implementation of our recommendations, but we also do want to acknowledge the positive practice when that does occur.
Yes, so what, if any, positive changes have been made to respect, or at least go some way towards respecting the rights of women in immigration detention since your report?
Well, again, I might take on notice, Senator, the broader question in terms of overarching engagement with the report, but the report itself detailed one small immediate change that occurred simply as a result of our inspection and raising questions during that inspection which related to access to particular facilities. It's a small example that doesn't go to the real heart of your question, but it does give an example where that oversight, asking of questions, raising those issues can lead to immediate change.
Right, what is that?
The access to the facilities.
The access to facilities. I think your report made about 20 recommendations, 20, actually it was more, 31 recommendations. And I think the Yonge Hill made 10 recommendations.
And I think in relation to women in detention, it was 31 recommendations with 11 being accepted or partially accepted, 4 being disagreed with, 15 being noted and 1 requiring government consideration.
What, if any, of the 31 do you understand have been actually implemented by the government?
Again, I'd need to take that on notice, Senator.
Well, rather than me just run through a series of iterative questions about implemented, etc., could you provide an update on where those recommendations are at on notice?
Certainly, Senator.
And I think you indicated earlier that you are contemplating further inspections in immigration detention facilities. Is that right?
One of the things we have been discussing, Senator, within the Commission is the use of follow-up mechanisms and the way that we're able to ensure that we are engaging to make sure recommendations are implemented, but also working with similar agencies, noting that we're not the only agency that conducts immigration detention inspections, and where it's possible to reinforce the work being done, for example, by the Commonwealth Ombudsman, that's a positive step that can be taken.
So have you had any structural engagement with the Ombudsman, who I think is the NPM for the purpose of these detention facilities?
Yes, on a number of levels, both in relation to the NPM function through OPCAT, and that's primarily through the mechanism of the OPCAT advisory group that not only myself but our National Children's Commissioner sits on. But in relation to immigration inspections, there is a regular meeting to exchange information that occurs at a staffing level.
All right. But you'll provide those updates on notice about the two reports?
Oh, certainly, Senator.
Yep. Could I take you now to your attendance at what was branded an anti-Semitism conference in the Gold Coast? I think I've sent some correspondence to yourself and the President in relation to that attendance.
No, you sent some correspondence to the President, is my understanding.
Were you provided with a copy of the correspondence?
I was, Senator.
And in that I raised my concerns and indeed multiple stakeholders' concerns with your attendance at the conference. You're aware of that?
Yes, I am, Senator.
What was the cost of your attendance at the conference?
There was no cost to the Commission for my attendance at the conference.
How is that?
Senator, perhaps to start at the beginning, there was no cost to the Commission for my attendance at the conference. There were no external funds sourced for my attendance at the conference. My attendance at the conference was personally funded, for the reason being that at the time I initially accepted, I had thought I was going to take my family with me and arrange some leave around the conference. That ended up not eventuating, but due to the need to ensure that we keep personal and work trips separated, at the time that I thought my family were going to accompany me, I made the decision to personally fund my attendance.
Did you receive any funding or any support from the organisation that was sponsoring and holding the conference?
No, Senator.
Yep. Did you seek any leave to attend the conference?
No, Senator, because it was within the scope of my work responsibilities.
It was within the scope of your work responsibilities? Was
yes,
it during
I spoke on a panel, Senator.
All right. How many days were you there?
The conference was for 2 days.
And were you there both days?
Yes, I was.
And you were speaking on one day?
I was. And I think I left from memory, Senator, slightly prior to the end of the second day to ensure that I could catch a flight.
There are a number of individuals who had quite disturbing track record there, one of which was a man called Jeff Shop, the former head of a US neo-Nazi organisation.
Mm-hmm.
Did you think it appropriate to be at a function where the former head of a US neo-Nazi organisation, who is criticised for, in many ways, for not even rejecting a bunch of his activities and conduct while a neo-Nazi, did you think it appropriate to attend?
Senator, I think the key part of your phrasing there was former head of neo-Nazis, and he is somebody who spoke at the conference about his disavowal of his former views, about the importance of countering hatred and about the importance of helping to de-radicalise and combat extremism. And I might note, Senator, he was on a panel, as I mentioned to Senator Faruqi when she asked similar questions earlier in estimates tonight, he was on a panel with Mubin Shaikh, who's a former jihadist extremist turned Canadian counterintelligence operative, and they spoke on a panel about how we go about countering extremism, countering hate, and reaching out to people who hold those views to de-radicalise them. My view is if we are actually serious about wanting to confront extremism and
you don't put those people on a stage.
Point of order, Chair. Sorry, point of order. Senator Shoebridge may not be aware, but Senator Faruqi prosecuted exactly these same questions and we're running out of time.
Yep. I have one more.
Perhaps, Senator, I can refer you to my earlier answer.
All right. Were you aware that did you have any engagement with former Labor Senator Nova Peris while you were there?
I heard her speak, Senator.
Sorry?
I heard her speak at the event.
Yeah. You're aware that she's previously shared a social media post describing Muslims as Satan worshipping cockroaches that need to be eradicated. Did you think it was appropriate attending an event where she was speaking, given she's made those statements?
Well, Senator, I would sure you would agree that being at a summit with somebody doesn't mean that you endorse or accept every single thing that person has ever said or done. And would note that...
But we're not just talking about anything. You would surely describe that social media post as grossly offensive?
Absolutely, Senator. But I would also note that as I walked into this room this evening, I walked past a portrait of Nova Peris Neeborn, who was the first Aboriginal parliamentarian. And while certainly I don't endorse
but you were at an anti-Semitism conference where she has shared a social media post describing Muslims as in the way that I described them. I won't repeat it because it's so revolting.
Senator, if I
and you
could
attended her
answer the
speech.
question, if I could answer the question,
Sorry,
Chair.
I just wanted to seek an indication of time from you, Senator Shoebridge, if I can.
This is my last point.
Last question. Thank you very much.
Well, my last point.
Senator, any language that dehumanises people, I would condemn. What I heard
Do you
from
condemn that language?
Senator, if I could answer your question, any language like that dehumanises people should be condemned. However, what I would say, at that conference, I heard her speak about confronting and combating anti-Semitism, and I would also say, and I did consider as I walked in here this evening and saw her portrait still hanging on the wall, she is somebody who I have respect for in terms of her broader contribution to public life, the commitment she has shown to combating anti-Semitism, and again, being at a summit with somebody or expressing broader support for their contribution to public life doesn't mean that you're endorsing every single thing that a person has ever said or ever retweeted. And my attendance at that summit and what I heard from all of the speakers at that summit was a deep commitment to combating anti-Semitism. Speakers who included the Deputy Prime Minister of this country, the Leader of the Opposition, the Queensland Premier had a message of support, the Queensland Leader of the Opposition was in attendance.
You don't effectively combat anti-Semitism by engaging in vile, dehumanising Islamophobia, such as former Labor Senator Nova Peris engaged in sharing that social media post, though, do you?
But, Senator, I've already expressed to you that I absolutely do not condone any language, including language that dehumanises.
But, Commissioner Finlay, you said you were there because you endorse and support her work fighting anti-Semitism. And what I'm putting to you is, how can you endorse the work of somebody who, as part of their fighting anti-Semitism, in their eyes, and I reject its fighting anti-Semitism, but as part of it fighting anti-Semitism in their eyes, engages in that vile, dehumanising Islamophobia that I put to you? How can you endorse that?
Thank you, Senator.
Senator.
That is your final question, and we'll move on.
Senator, I haven't endorsed that statement, and I've said to you, being at a summit does not mean that you're endorsing every single thing that somebody has ever said in their life. It was a summit designed to combat anti-Semitism. What I heard from all of the speakers at the summit, and which I do endorse, was exactly that. And again, it was a summit that had the attendance of significant people from across the political spectrum, with either in attendance or messages of support from the Deputy Prime Minister, the Leader of the Opposition, the Queensland Premier, the Queensland Leader of the Opposition, and a former Prime Minister, namely Julia Gillard. It was a summit that had broad support, that was non-partisan and that was dedicated to confronting and combating anti-Semitism. That is what I support, Senator.
Thank you, Commissioner. I'll now share the call. Senator Chandler has indicated she's got a very short block.
Very short block, Chair. I just wanted to go back to the Race Discrimination Commissioner, if I could. While he's walking up to the table, I have the articles that were linked in the tweets that I'd previously tabled, so if I could get those articles tabled as well, Chair, that might be useful. And then there was one in the Brisbane Times, yeah.
Thank you. We'll take those.
Thank you. Commissioner, have you had a chance to look at those tweets that I showed you and determine whether or not you tweeted them?
I looked at the tweets, yes.
Can you confirm for the committee whether you tweeted them?
Oh, I haven't been able to go through. This is an old Twitter account. I don't even know if I've got access to it anymore, so I haven't been able to do anything further.
Right.
All I can do is look at what you've given me.
On notice, would you be able to provide to the committee? I mean, yeah, it would be wonderful if you could confirm that tonight, but I recognise it's probably not going to happen. And I just want to put to you this question again about whether Australia is a racist country. I think, and I'm paraphrasing you slightly, you know, you think there are racist elements to Australia. I'm just trying to be abundantly clear on what your view is here, Commissioner.
What's your question, Senator?
Do you think Australia is a racist country?
So I think you've asked me this before, and I'll refer to my previous answer.
Which was a lengthy answer that didn't really go to the heart of the question. I mean, I think it's a pretty simple yes or no, isn't it?
I don't think it's a simple question at all, Senator, because you're asking for a whole country to be described by one word. That's a very simplistic and reductive way to approach something. It is much more useful to think about how racism manifests within this country so that we can then bring about the change necessary to make the country better.
Let's try an easier one. Is Australia a good country or a bad country?
Australia is a wonderful country to live in for me and for my family, and I'm glad to be here. But that doesn't mean we can't make things better. To ignore the way that people's lives can be impacted by racism is doing an enormous disservice to them. So again, Senator, as I said to you before, being truthful about people's experiences and taking change to make their lives better is genuinely the way we can make our society better for all of us.
Okay, that's still an awful lot of gobbledygook to what I think should be a pretty straightforward question to answer. But thank you very much, Commissioner, for coming back up to the table.
Thank you very much, Senator Chandler. That means that we're now in a position to say farewell to the Australian Human Rights Commission. Thank you very much for your time this evening. And we'll take a short break, a short suspension while we welcome the Office of the Commonwealth Director of Public Prosecutions to the table. With the Office of the Commonwealth Director of Public Prosecutions. Is there an opening statement?
No.
Thank you very much. We'll proceed directly to questions and I'll go to Senator Roberts.
Thank you, Chair, and thank you all for appearing today. I've got two sets of questions. They're both fairly brief. Firstly, I want to go to your decision not to lay any charges in relation to the 2023 Defence Taipan helicopter crash in the Whitsundays. 4 Defence Force personnel, Captain Daniel Lyon, Corporal Alexander Naggs, Lieutenant Max Nugent and Warrant Officer Class 2 Joseph Laycock died in the crash off the Queensland coast, as you'd be aware. Comcare, the country's workplace health and safety investigator, delivered a brief of evidence and investigation to you where they identified 2 significant breaches of law, Category 1 and Category 2 offences. Media reporting indicates that the decision to not lay charges may be under review. Is that accurate? And if so, is your review still ongoing or has it been finalised?
Thank you, Senator, for your question, and I'd like to thank the committee for its interest in the work of my office. Before I answer your question, Senator, I would like to take this opportunity to acknowledge the loss of lives, the loss of Captain Daniel Lyon, Corporal Alexander Knaggs, Lieutenant Maxwell Nugent and Warrant Officer Class 2 Joseph, known as Philip Laycock, and also to recognise the grief of their families. Senator, your information is correct. The decision that was made not to lay charges in response to in relation to the briefs that were referred from Comcare is under review. That's a review I'm personally conducting, and that review is ongoing.
When do you expect it to be finished?
I can't give you a date for that, Senator. I'll give it the attention it deserves. It's an important matter and needs to be done thoroughly.
So why did you decide to not lay those charges in the first place when the federal investigator lays a brief of evidence on your desk that very clearly identifies potential offences?
Thank you, Senator. Prosecutions are taken in accordance with the prosecution policy of the Commonwealth. This is a publicly available document. It has it outlines the steps that are undertaken to determine whether a prosecution can be laid. The first step is whether there's a prima facie case. Has there been an offence committed? The second step is, are there reasonable prospects of conviction? And this involves a thorough analysis of the evidence contained in a particular brief of evidence. And it's only then, if there are reasonable prospects of conviction, that the third stage of the test, whether the proceeding is in the public interest, is considered. In this case, it was determined that there were not reasonable prospects of conviction based on the evidence contained in the briefs referred by Comcare.
And that's what you're reviewing?
Yes.
Thank you. The families want this to go to court. You'd be aware of that, I'd say?
Yes.
Okay. The workplace investigator says this should go to court. The Commission of Inquiry has had extensive evidence. Then you say, no, we aren't laying charges. Why not? What turned you against it?
Well, as I said, Senator, the evidence that was referred on the briefs by Comcare was considered, and on the basis of that evidence, there were not reasonable prospects to convict. I understand the family's desire for this matter to go to court, and all of the things that the family have identified are relevant to the public interest, and I can say that if there were reasonable prospects, the prosecution of these charges would clearly be in the public interest. But that's the third stage of the test.
Do any of your employees, thank you, do any of your employees who worked on the referral for this Taipan helicopter crash have any current or previous association with the Department of Defence? You can take that on notice if it...
Yeah, not to my knowledge, but I'd have to take that on notice.
Not to your knowledge, thank you. Do you feel you have adequate resources and budget to take on this matter?
Yes, Senator.
Okay, thank you. I appreciate your direct answers. It's refreshing. Thank you. I'm alarmed, turning to another case, I'm alarmed by the recent trend in some states to reduce sentences for heinous crimes because of historical, cultural experiences. I'll get to the federal implications here. One recent state case, this is a state case I'm citing, involved a person from overseas who was convicted of child sexual offences and had his sentence reduced because the trial judge felt that because of his previous exposure to such activity, it would be unfair for him to be severely punished if he believed what he was doing was not seriously wrong. I think that's horrified a lot of Australians, and constituents have contacted us. Since when has the law reduced sentences simply because the offender thought it was okay to commit sexual offences against children?
Thank you for your question, Senator. I'm not sure that that's how the law operates in the way that you've conflated a number of factors.
Mm-hmm.
When a sentence is imposed, and I'm really speaking about the role of courts here, which is outside my direct operation, but the role of courts when they're determining what sentence to impose consider a whole range of factors. Many of those are set out in the Crimes Act, but some are set out by the common law, by the courts as they develop the law of sentencing over time. And those factors include the personal circumstances of both the victim and the offender.
So I think some members of some of our constituents, a lot of our constituents, would be very upset with the decision. They're telling us they are. They think the judiciary needs to be re-educated, but that's not for you. I accept that. Can you reassure the Australian public that such a claim would not result in a similar discount if the offence was a Commonwealth one?
Senator, I'm not sure precisely what the claim is. I can say that we make submissions to courts about what we think the appropriate sentence is, what we think are the appropriate factors relevant to sentence, but those factors do include the personal circumstances of an offender. That's simply the state of the law, and that's set out in the provisions of the Crimes Act, which deal with how sentences are to be imposed in relation to federal offences.
Isn't it pretty clear-cut that molesting a child, sexually abusing a child, sexually assaulting a child is exactly that? And the law would be pretty clear-cut in that, wouldn't it?
Well, is exactly an offence? Yes, it is an offence.
And it would, the sentence would be lessened if the male comes from a country where paedophilia is allowed?
No, Senator, I'm not sure of the particular details of the case about which you're speaking. At a general level, at a high level, the personal circumstances of an offender are relevant to determining what the appropriate sentence is for every case. And it's not a question of whether that lessens the gravity of the offence. It's just one of the factors that goes into the mix in determining what is the appropriate sentence for a case, for a particular matter.
I'm at a loss for words. Anyway, thank you very much. Thank you, Chair.
Thank you, sir.
Thank you, Senator Roberts. Senator Shoebridge.
Thanks, Chair. Thanks, Ms Sharp, for your attendance and your work in the office. You were asked some questions by Senator Roberts about the decision not to prosecute in relation to the Taipan helicopter deaths.
Yes, Senator.
Were you in possession of the 200-page report from the Aviation Safety Investigative Unit when that decision was made?
I'm not sure whether that report formed part of the briefs that were provided to my office by Comcare. The Office of the CDPP has no investigative function. We don't bring in evidence. We consider evidence that's provided to us by our partners.
But you make requisitions and ask for additional material if you think it's needed?
We can.
Well, if you didn't have it, did you ask for it?
I'd have to take that on notice in relation to this particular case, in relation to that report. Senator, are you referring to the, let me just be clear.
The Aviation Safety Investigative Report that was given in the context of the IGADF inquiry?
Sorry, I can clarify that the Comcare investigation was a separate process to both that and the inquiry known as the McMurdo inquiry, if I can use that shorthand. The Comcare briefs did not contain all of the evidence heard by or available to the asset investigation, the Defence Flight Safety Bureau investigation.
No, but one of the most critical pieces of evidence, at least in that inquiry, to try and understand how and why things happened, was a 200-page report from the Aviation Safety Investigation body. Are you saying that wasn't available to you and you didn't requisition it before making the decision not to prosecute
Senator, the briefs were forwarded to my office. There were two briefs on the 27th. One was forwarded on the 27th of March of this year and one on the 25th of June of this year. We were aware the briefs were coming and we're prepared to undertake an analysis of those briefs. Given the timeframes in relation to the matter, as I understand it, there were no requisitions done at that point in time. But if there were no requisitions done as far as I'm aware.
Can you explain
on notice.
Why there wasn't that requisition made? I mean, that report was, I think, released on the 21st of May. It was available since May.
Well, that's after the first brief was referred. But I would also say that that's a report. That's not necessarily an evidence that could impact the outcome of analysis of the evidence on which a prosecution could be mounted.
You wouldn't know if you didn't read it.
Well, it wasn't available in relation to the first referral, and I'd have to take on notice what part of the report was on the second brief.
Well, I mean, it was the subject of widespread public commentary.
Yes.
You know, how do you say to the families there wasn't sufficient evidence to prosecute the matter, if you haven't looked at some of the most critical evidence that was available if you merely requisitioned it?
Well, there are some assumptions in your question, Senator, which is that the contents of the report in and of itself would contain evidence that would have made a difference on the analysis of the evidence on the brief. I'm not in a position to answer that question here because I'm partway through my review, and so I simply don't know the answer as to whether it would have made a difference, but I would repeat that the report produced by that inquiry is not necessarily in and of itself evidence that could be relied on in court or in any admissible form.
That was a report that was done and fed into that inquiry, but it was a report that was done as part of the Army's aviation safety regulatory process, a fact-finding report. It wasn't the report of the IGADF inquiry. It was a report that was provided to that inquiry. Do you understand the difference?
As I understand it, Senator, you're speaking about the report from the Defence Flight Safety Bureau.
Correct.
Yes, I don't have a working knowledge of that report as I sit here, so I'm not in a position to engage in a debate about those matters.
Well, can you provide on notice what you've already agreed to, whether or not it was provided and whether or not there was a requisition made for it?
Yes, Senator.
And if there was no requisition made and it wasn't provided, why that was the case?
Yes, I can take that on notice, Senator.
Were there any directions given by the Defence Minister or any other officer in relation to 12D of the Work Health Safety Act about Australia's defence?
I'd have to take that on notice, Senator. I don't know.
Were there any directions given about evidence or other material being provided or not provided to the CDPP under national defence provisions in the Work Health Safety Act at all?
I don't know as I sit here, Senator. I'd have to take that on notice. I'm sorry.
All right. Thanks, Michelle.
Thank you, Senator.
Thank you very much for your assistance there, Senator Shoebridge, and for your appearance this evening. We're now in a position to release you. Thank you.
Oh, sorry.
Oh, sorry.
No. Just, there's one other matter that I have to do. It was very close. Sorry, Michelle.
You nearly got away.
I was all type Annie, and I'd forgotten entirely about another matter, another line of inquiry.
Can I just seek an indication of time from you, Senator Shoebridge?
I think it'll be very brief.
Okay. Almost got away.
And I'm sorry, Michelle, and to your team. The matter of Richard Boyle, what was the final cost to the CDP for that prosecution?
As at the 31st of August of this year, the total external legal costs to the CDPP was $339,703.
Okay.
Exclusive of GST.
And have you kept a tally of what the internal costs were, staff hours or the like?
No, the CDPP doesn't keep internal costings in that way.
Do you know how many staff were attached to the prosecution?
I'd have to take that on notice because the proceeding went for an extended period of time.
And I'm more than happy for that to be provided over time, if no doubt it rose and fell over the course of the prosecution.
Yes.
What was the final outcome?
So in relation to the 4 charges which ultimately proceeded, Mr Boyle was discharged without conviction and put on a good behaviour bond for a period of 12 months.
And how many charges were preferred by your office but ultimately withdrawn?
How many... Sorry, could you ask the question again? And I might ask Mr de Crespigny to assist with the...
How many charges were preferred against Mr Boyle?
Originally... Yeah, please.
Senator, on my understanding, the original information commenced with 66 charges. The indictment, which was presented, had 24 counts. In March of this year, 4 of those counts were withdrawn after further analysis of digital forensic evidence. Then the remaining counts were reduced to the 4 counts which went to sentence as a result of the plea negotiations, which allowed the remaining counts to be rolled up into from the number of 19 or whatever down to the 4 which proceeded to sentence.
And when, in terms of the information containing 66 charges, was that provided? Was that a document of your office, or was it a document provided to your office? The information.
The original information, which is what a summons is known as in South Australia, would have been. I'm fairly certain from our office.
Okay.
If it wasn't, I'll correct it.
And when was that information / summons
That
lodged?
was in January 2019.
2019. So Mr Boyle has faced 6 years of criminal proceedings, 66 charges. The Commonwealth has spent multiple hundreds of thousands of dollars persecuting him. You knew at the outset that there was a strong public interest element to the work he did. And after all of that trauma to Mr Boyle, all of that public expense, fighting 66 charges, you eventually succeed in a plea to 4 charges, and he's discharged without conviction and placed on a good behaviour bond. Was that a rational use of public money?
Yes,
and
Senator.
was it a decent thing to do to Mr Boyle?
Yes, Senator. Every prosecution, as I outlined before, is brought in accordance with the prosecution policy. There were the brief was assessed and there were reasonable prospects of conviction, and it was considered that it was in the public interest to bring the prosecution. Now, there are several factors that might pull different ways in public interest, but ultimately it was determined that the prosecution was in the public interest.
Well, I'm asking you to look at it now in light of what's happened. Mr Boyle, who was a whistleblower whose actions were endorsed by a Senate committee, led to substantial change and reform in the tax office, eventually persuaded the court that his conduct was such that he should be discharged without conviction and placed simply on a good behaviour bond, and yet you spent 6 years chasing initially 66 criminal charges against him, carrying potentially years and years of of prison time. You spent more than $330,000 just on external lawyers, and heaven knows how much of the public resources in your office, and you obtained only those 4 charges, and he's discharged without conviction. Are you sure that was in the public interest?
Yes, Senator. Can I just clarify?
How on earth is that in the public interest?
Well, of the 6 years that the proceeding took, there are a number of elements to the proceeding, including various appeals, and so these things take time. It's simply a product of the system that some proceedings take a longer period of time to resolve than others.
You don't have any reflection. Your office has no reflection on whether or not there was a sensible use of public resources, the sensible use of your office's resources, noting that the end result, after 6 years of litigation against Mr Boyle, was 4 charges, plea bargain, discharged without conviction. You have no reflection on that?
It's not that I have no reflection on it, Senator. It's that the prosecution was brought in the public interest and, in my view, was in the public interest. Ultimately, the 4 charges to which Mr Boyle pleaded guilty, as Mr de Crespigny outlined, was a wrapped-up version of 20 charges, and they were resolved in that way to facilitate the matter resolving. In terms of being exposed to years of prison time, when the proceeding was initially brought, the prosecution consented to the matter being dealt with summarily. Mr Boyle did not consent to the matter being dealt with summarily, and then therefore it went on in the indictable stream.
And so, you wanted something with 66 charges dealt with summarily. He insisted upon testing it and ultimately only faced 4 charges. That seems like a very sensible decision for Mr Boyle, doesn't it, rather than addressing 66 charges summarily?
Well, I can't comment on whether it was sensible from Mr Boyle's perspective. I can comment on how the prosecution was conducted, and in my view the prosecution was brought appropriately, was in the public interest, and it's resolved appropriately. Senator, our goal is not to get the biggest sentence possible, it's to get the right sentence in cases.
Minister, are you comfortable with the Commonwealth spending hundreds of thousands of dollars pursuing Mr Boyle for 6 years, initially on 66 criminal charges, in circumstances where his whistleblowing was endorsed by a Senate committee, led to fundamental and important changes in the Australian Tax Office, and then the end result is that he is discharged without conviction? Do you think that's a sensible use of Commonwealth resources?
Well, what I would say, Senator, is that the Office of the Director of Public Prosecutions is, of course, an independent prosecution service. The government doesn't intervene in the decisions of the DPP to make those decisions about prosecution, and the directors stepped you through all of the decisions that were made and how it was made in line with their prosecution policy.
The attorney can seek a review of conduct of the CDPP. Has there been any efforts to get an explanation or a review of the CDPP's conduct in relation to Mr Boyles from the attorney?
No.
No, Senator.
Minister, you don't think you? They each said.
In unison.
They each said. Minister, will the attorney be seeking such a review?
Senator, I mean, I can take that question on notice. I think you have asked questions, obviously, about this matter on a regular basis through Senate estimates. It's been well ventilated. There are opportunities, of course, to ask more questions throughout the day on our whistleblower policy, our reform in that area, but I can take that question on notice for you.
And lastly, to the CDPP, Ms Sharp,
yes.
Has there been any prosecutions for what are now called revenge porn offences using deep fakes following the legislative reform the Parliament did last year? I think if you remember, there are existing criminal offences which were extended to include deep fakes.
Senator,
yeah, the short answer is yes, and Mr de Crespigny has the details.
Senator, there's been the offence provisions dealing with deep fakes, but actually dealing also with non-consensual sharing of intimate images, which is an offence against section 474.17a and 474.17AA. We've had one prosecution that's been recently completed. It was not for a deep fake image, it was for some real images, but which had been shared without consent.
Okay. Have there been any prosecutions commenced for the deep fake offences?
No, the matter I've mentioned to you is that...
So that's the only one, and that was for not a deep fake?
Yep.
Okay. Have you... Minister, has the, well, through you to the department, has the department reviewed that recent ACT case involving a public servant creating deep fakes of colleagues where the prosecution failed because police couldn't prove distribution of the material? Are you aware of that matter? And the difficulties with the proof on distribution were insurmountable for the prosecution in that matter?
Yes, Senator, I'm aware of it.
Have you considered whether or not there may need to be any legislative reforms to assist in proof as a result of that for the Commonwealth offences?
So we've raised that with states and territories. For the Commonwealth, we obviously depend on having a constitutional basis for our offences, and so they're constructed around use of a carriage service. If that's not used, we've obviously had that conversation with states and territories about covering creation of images where there's no use of a carriage service.
So is it because an element of the offence under the Commonwealth is use of a carriage service that you're confident that the Commonwealth would pick up a distribution element because it's an essential element of Commonwealth offence?
That's right. If it's online, yes.
All right, I understand. Thank you.
Thank you, Senator Shoebridge.
I've genuinely finished this time.
Thank you. We're now in a position to release the Office of the Commonwealth Director of Public Prosecutions. Thank you very much for your time this evening. We'll take a short suspension while we welcome members from the Administrative Review Tribunal. Thank you very much for your attendance here this evening. Do you have an opening statement?
Thank you, Chair. Michael Hawkins, Chief Executive Officer and Principal Registrar of the Administrative Review Tribunal. On the eve of our first anniversary of the Administrative Review Tribunal, I have offered a few remarks on our achievements and the challenges that we faced over the past 12 months.
Can I ask you to table that?
Those up?
Yeah, thank you very much. Be a great assistance to the committee.
Happy for you to release this if you like.
I think Senator Scarr would be very disappointed. He's got a couple of questions for you. So I will go directly to questions, if that's all right. Senator Scarr.
Before we start, Senator, I'd like to congratulate you all on your appointment and reappointment to this committee, and my colleagues and I look forward to assisting you in whatever way we can. Particularly delighted to see Senator Scarr here and his ever thoughtful analysis of our annual report.
That won't get you anywhere, Richard. that was a good try.
I'm glad we've reached comedy hour.
Bring it on, Senator.
Registrar, what's the morale like at the Administrative Review Tribunal?
Morale is mixed, and you'll see in my opening remarks there, Senator, that we have faced some challenges in our first year. First of all, we still have misfunctioning case management systems. I've said before, I've been quite open about it, that they are years past their end of life. We are working desperately to build a new case management system. Throughout the year.
Hawkins, I am loath to interrupt you, but would you mind please handing your opening statement over so we can get it copied for the committee? I'm sure it'll assist Senator Scarr in his questions. Sorry for interrupting you.
Not at all.
Go
on. Senator, during the first 12 months we have suffered some chronic short staffing where we've been trying to recruit staff throughout the year. We've also had a shortage of members against what we've been funded for. But most importantly, and of greatest concern to us, of course, is the avalanche of lodgements that we've had during the year, 85,000 during that last financial year, which is more than 100% on the number of lodgements we had only 2 years ago.
Yep. I've had a look at the 2024 Have Your Say APS Employee Census Survey. I understand the APS has conducted the survey for 2025. Do you have the results for the 2025 survey for the ART?
Yes, I have seen that, and we'll be publishing those in November.
Okay. Well, can I put a few examples to you? In the 2024 survey, it said the percentage of staff who were satisfied with their job was 72%. What was the result in the 2025 survey?
Senator, I will ask, but I may need to take that on notice.
Well, this comes back to Morale Registrar. I've been informed that that figure actually dropped to 63%.
That is
in the
probably
next
the case,
survey.
Senator, I'll be honest and say I'm surprised our results were as good as they were.
Really?
And that's not to say good, but I mean, let me rephrase that they weren't worse than what they were because of the challenges we've been facing. Our staff are overworked. We're facing, as I said, twice the number of lodgements that we had only 2 years ago, 79% more than we had the previous year. Our staff have been overworked, I acknowledge that.
I'll give you another example. Internal communication within my agency is effective. 2024, the result was 52%.
Sorry, what was that number?
52% in 2024, and as I understand it, that number has dropped to 43% in the 2025 survey. Does that sound accurate?
That could be, Senator, yeah.
Okay. And is that a consistent theme, Registrar, across a lot of the indicators? There's been actually falls from the 2024 results?
There have. What I might say, though, Senator, is that the majority of our staff are in two key sections. The first one being case management and the second one being in member support. So the majority of our staff are in those two sections. And those are the two sections that have been impacted most by the amount of work that's been brought about by the lodgements that we've received, the short staffing that we've had, and of course the exposure that we've had to those dysfunctional case management systems.
Okay. The Chair wants to release an agency.
I've just got some advice that we're in a position to release the Office of the Commonwealth Ombudsman, the National Student Ombudsman. Thank you very much for that indulgence, Senator Scarr.
Thank you. We're always happy to release people when we can. That was the tradition set by a previous chair.
Recognition of reality.
You've talked about significant shortfalls in terms of resourcing, Registrar. Are you saying that members do not have support staff, they don't have associates, and that matters stood down to do more complex hearings? Has that occurred?
We have a different member support model that we've employed in the new tribunal. where it hasn't been an associate model. It's been a pooled resource. And the reason we've done that is to make it easier actually for staffing, that they are all providing a consistent service to members. When there is leave and absences, other staff are able to pick the matters up.
Okay, well, this is, can I put a few things to you? And I come back to the Morale Registrar because we're being given information from various sources, which always goes to Morale. It's been put to us that associates in the tribunal have largely been replaced with hearing officers who do not stay in the room during hearings. Is it a fact that members have to adjourn hearings each time a witness appears so someone can come to the hearing room to bring the witness in and swear them in?
That's probably the case, yes, Senator.
Okay. Have there been complaints from the professional law groups, so from Law Society or other groups representing the legal profession or other representative groups about this new practice?
There have been.
Okay. And what has been the nature of those complaints, just generally?
That it doesn't look professional.
What role has the President had in terms of bringing in those changes? Presumably these, I mean, if you get complaints from some of our peak legal, and I don't know if they are the peak legal bodies, but assuming they are, if you're getting those sorts of complaints, presumably they're elevated to the President. What's his response been?
The President has been supportive of the member support model that we have instituted.
Okay, well, the corollary of that is the President doesn't appear to be mindful to change the support model that's been introduced, notwithstanding the complaints from the profession. Is that a correct characterisation?
No, we're doing we're about to do a pulse survey on members very shortly to test the reaction to the member support model. I wouldn't say the views that you're expressing are universal.
Okay. Is it taking longer to actually have hearings because of this new model?
Is it, sorry?
Taking longer to actually have hearings because of this new model? Because presumably there are going to be delays.
No, I've got no evidence of that.
Do you have any evidence it's not taking longer, or just no evidence?
That's circuitous, no evidence at all.
Okay,
understood. That has not been put to me.
Okay, but you're undertaking a review in relation to
We're doing a pulse survey of members, we are.
Okay, understood. I want to go to your last report, and you know I'm always diligent in terms of reports, and you have talked about resourcing, and you actually preempted the major question I was going to ask. You turn to page 20 and 21, you've got 85,845 cases lodged, total number finalised 46,447. So that to me indicates that the tribunal is in dire straits in terms of managing workload. Is that a fair assessment?
Well, as I said, I did make the point about under-resourcing both in staff and members. We've been funded for 315 FTE, and as at the end of financial year 2025, let me just get my numbers, we had it was about 298 FTE, but they were appointed up to the end of the year. It wasn't as though we started with that number on the 1st of July. So we have finalised, if I can say, we have actually finalised that number of matters that we were physically resourced to finalise.
Yeah, and and this qualification you add in terms of finalising the number of matters you're resourced to finalised is, well, the word that comes to my mind is quaint in a way. It's obviously some thought went into that qualification. Has the President raised with the attorney issues around lack of resourcing for the ART?
Oh, regularly, Senator. I have as well, that we need to get these members appointed.
Okay. When you say regularly, how often?
Senator, I just want to. I think you talked about resourcing, but there's a difference between resourcing as in people appointed and funding for the tribunal.
Yeah.
because I think the funding is there. The funding model was developed with the stand-up of the Administrative Review Tribunal. It's a flexible, demand-driven funding model to support the tribunal. Now, I acknowledge that even within that funding model, since that funding model was developed, there has been a surge in some categories of cases, and obviously there's a range of possible responses to that. But I just want to clarify the difference between challenges about being able to engage the number of people that the tribunal has been funded to be able to.
I understand the distinction. Yeah. So is the question you don't have enough members?
The question is we have the funding. We don't have the correct number of members pursuant to that funding model.
What is the shortfall?
As I said, as at 30th of June 2025, the number was 315 FTE, and we were about 294, I think. 292 FTE. Moving forward, our FTE should be about 430.
430?
For this financial year, and we are still at about 315.
Okay, so what's happening in terms of turnover? In terms of people leaving the ART? We've spoken about the morale issues. What's happening in terms of people leaving?
During the financial year just completed, we lost 32 members.
Okay. Did that? How does that compare with, say, an average year in the AAT?
In the AAT, I'd have to take that on notice, Senator.
All right. Well, from recollection, say in the year ending 30 June 2023, would it be normal to have, say, more than 20 members leave?
I'll have to take that on notice. I've got no recollection.
All right. And what reasons are they giving when they're leaving? Are you doing exit? So
we are with some. Some offer an opinion on their way out. Being a member of the tribunal simply isn't for everyone. Decision making is hard. Others, the role wasn't what they expected it to be.
Okay. Are any, Ms Jones, we've talked at length in previous estimates in relation to the recruitment process for the ART. Approaches being made to previous members to try and fix this stopgap, to try and fill these numbers, because the ART is obviously in a dire situation from a member perspective.
So there's a range of things that I'll ask Ms Harvey to talk to in terms of appointments processes, and it is for us a very significant priority. We recognise the challenges of not having the members for which the tribunal is funded. I do note that just as recently as 21st of August, 58 general members were reappointed for a further 3 years. And that is in particular to focus on some of that older caseload around complex migration and protection matters. But I'll see if Ms Harvey can add some further detail for you.
Thanks. Senator, I understand there's currently 359 tribunal members, which is people as opposed to FTE, so just acknowledge
part-time.
Acknowledge those differences there. But in the last 12 months, since the tribunal's commencement, the government's appointed 83 members to the tribunal, and that includes 62 reappointments. There is a current recruitment process on foot. That commenced. That was advertised from the 27th of August until the 12th of September, and both on the webpage, our website, in national papers, digital media, and was also a range of organisations were contacted as part of that recruitment.
So, Ms Harvey,
process.
sorry, we just got limited time. Sorry.
Yeah, no,
sorry
that's okay. So,
how many members are you actually looking for now?
Senator, I don't have a number in front of me about how many we're looking for, but...
you must have some sort of general...
Sorry.
Is it 3 or 3 dozen?
No,
or?
We are looking to provide a list from which all the vacancies could be filled. And the specific numbers we can take on notice.
Well, Registrar, how many members are you looking for?
In excess of 100 FTE.
In excess of 100 FTE? So you have a shortage of 100 FTE in terms of ART members?
As against what we're funded for, correct.
As against what you're funded for. So you got the funding, but you're short 100 members.
We are.
No, I think there's a difference between 100 members
FTE.
and 100 FTE.
I'm talking 100 FTE. I'm sorry, only talking in terms of FTE decision.
No, I understand.
Yeah.
So in terms of if they were only part-time, you're looking for more than 100. Is that correct?
That's true.
So how did we get to this situation, Minister?
Well,
with 100?
Senator, what I'll say is 3 things. Firstly, what we're talking about is meeting a staffing level to meet increased resourcing, which is what we've provided, okay? I'm assuming you're not opposed to that, providing additional resourcing to the ART. The second thing I'd say is that we have made sure that we're implementing a merit-based appointments process, which the department can talk you through. We're doing that in a very deliberate way. I think that is what the public would expect. After the former AAT, when we came to government, had about 80 appointments of who were political appointees. That's why we abolished the former AAT in the first place, and that is why we are going through a merits-based process. What I'd also say, and I think the Secretary alluded to this, is there are other ways that we can assist the tribunal in managing its workload, and we're working through those processes as well.
I think it's fair to say, Senator, that with the demand-driven funding model, calculations are made during the budget process. As I said, we've received 85,000 lodgements, which has had a serious impact on the calculation of that funding, which in turn has an impact on the number of members that we need. And I appreciate that there's going to be some time delay between the difference in the funding and the appointment of the members. So,
but Registrar, you also, I'm sorry, I'm running out of time. Registrar, you also accept though, if your scores in your employee survey are falling in terms of morale, and you've spoken about that, there becomes an issue with respect to whether or not this is an organisation that people want to join if the morale is falling. Is that a fair comment?
It's a comment based on a moment in time where we're overwhelmed by lodgements, that we still have a case management system that isn't functioning, and it has taken us time to resource our staffing levels.
Have you had any meetings with the Attorney-General in relation to this, face-to-face meetings?
We've had a meeting with the Attorney, okay, and I have drawn to her attention these 3, what I call a perfect storm, scenarios that exist at present.
Did the President attend that meeting with you?
The President was not present.
Why wasn't the President in attendance?
I believe he was on leave.
He had something more important than this?
He was on leave.
The President, though, has met with the Attorney-General, I believe.
Oh, yeah, sorry. Yeah.
But not in...
My remarks then were made at an all-staff meeting where the Attorney was present, and I made clear to the staff, obviously pointing out to the staff that I appreciated and understood the concerns that we had and wanted the Attorney to understand that as well.
Have there been...
So the President and I have together met with the Attorney and again made those points clear.
At the same time?
Together, yes.
Right, okay. Have there been concerns raised by members of the Tribunal with respect to the management style of the President?
To whom, sorry? Not to me.
No one has raised concerns with you with respect to the management style of the President, including with respect to management of leave requests?
Management of leave request?
Correct.
Not that I'm aware of. No, not with leave requests, no. The leave is at the discretion of the President, as you're aware. I think we had this discussion last time we were together. No, I'm not aware of issues involving member leave.
Okay. All right. If perhaps you want to, could you just take that on notice and I'll give you an opportunity just to check.
Sorry, your specific query is?
Whether or not any concerns have been raised by members with respect to the President's management of leave requests, personal leave requests and other leave requests.
All right.
And lastly, because I'm aware we're running out of time, has there been an instance of an ART member having been appointed and resigning within a week of their appointment? And if so, what were the circumstances of that?
I'm not aware of that scenario. I am aware that somebody resigned during the induction program because, again, after a few days of induction, he realised the role wasn't for him.
So, Secretary, how's that happen?
I think
in terms of the recruitment process.
Yeah, but I mean, he would have been, actually, I don't know if it's a he or she, but that person would have been assessed against the selection criteria and met the criteria. There's a process by which their claims for the role are assessed. But if that person, upon starting the job, has a personal revelation that it's not the role for him, probably it's in the best interest of both the institution and the individual that they work that out fairly quickly.
All right. Well, good luck, Registrar.
Thanks, Senator.
Thank you very much for your time this evening.
I just have a few questions.
Oh, okay. Senator Shoebridge.
Yes, that's okay. I know it's late, Chair. The Registrar, when tribunal members transferred over from the AAT to the ART, did they keep all their entitlements?
They kept all of their vacation leave entitlements but did not have their personal leave because personal leave is not an entitlement.
And when you say personal leave, sick leave,
yeah,
carers leave and the like.
Because that's not an entitlement.
What were the provisions for personal leave under the AAT for tribunal members?
There were none. It was the same. There was no entitlement to leave as such. There was a nominal 20 days in the Orion pay system.
Okay, so the practice was individuals had 20 days a year for personal leave. That was the practice.
It wasn't so much a practice, it was a record-keeping device.
Well, did people take up to 20 days of personal leave as tribunal members? Was that the practice?
It in the sense that it wasn't an entitlement. They could take leave and request leave, yeah.
Yes, and if they requested personal leave, were they granted personal leave up to that 20-day nominal threshold? Is that the practice?
At the discretion of the President, yeah.
Well, were you aware of any instances where it was refused?
I was not.
Yep. So I asked if it was the practice, and it was the practice.
It was a power that was delegated to the division heads in the AAT
Yep.
and now been delegated to the jurisdictional area leaders in the tribunal.
And had the 20 days, did it accrue in the record keeping? If they weren't taken in year one and they proceeded to
yes,
year two,
it did accrue, yeah.
Mm-hmm. And so at the time the AAT transferred to the ART, people would have been aware of what their nominal accrued personal leave entitlements were? That would have been visible to them?
They would have been.
And when they transferred into the ART, they disappeared?
They disappeared.
And that's caused friction, hasn't it?
It has. But I think the intention was to commence all members at the same level.
Well, you see, Senator Scarr was asking you if there'd been any issues raised about leave entitlements, and you said no. Is that because you say that the personal leave provisions, well, I won't try and guess what you're thinking.
Yes, in that context, yes, I'm aware of that.
He just asked you about it?
Yeah. Sorry, in that context, I'm definitely aware that that has been an issue. I wasn't, sorry, in answering Senator Scarr's question, it was more a question of has it been brought to my attention that complaints have been made about the leave issue? And I'm not aware of complaints having been made.
You're aware of significant
unrest,
dissatisfaction with what happened?
Yeah.
And you say none of them have found that have become complaints?
Not that I'm aware of, that's correct.
All right. What does how has the dissatisfaction played out?
Talk amongst fellow members, I suspect.
Yeah. How has it been addressed? Is it just been left unaddressed?
No, staff, it's been left unaddressed in the sense that it's been made clear that that leave that was nominal was not an entitlement under the REM Tribunal or the AAT Act.
Who made the decision not to transfer that accrued leave over from the payroll and record keeping of the AAT to the ART? Who made that decision?
That's a power that's been delegated to the President, so it was the President's decision.
President. And was there any consultation with tribunal members before their personal leave was cancelled?
Not that I'm aware of.
You can understand why that might lead to significant grievances, can't you?
Yes, I can.
And that is leading to significant grievances, isn't it?
It is.
Minister, were you aware that tribunal members' personal leave that they thought was theirs was wiped when they moved from the ART to the AAT? From the AAT to the ART?
Senator, I think the CEO has explained to you that that was a decision of the President. If there's more information we can provide you, I'm sure the department will, but it's not a decision of government.
Well, it's a decision of a significant agency in the Attorney General's portfolio, and it's about a workplace entitlement, and you're a Labor government. Is that not a matter that's come before the Attorney General, either the current or former Attorney General?
I don't think, to add to my answer.
Secretary, were you aware that tribunal members' personal leave balances were wiped when they moved from the AAT to the ART?
I'm not sure. I'd have to take it on notice, and Ms Harvey has only recently taken over responsibility for the Administrative Review Tribunal, but I'm just trying to understand this issue. We might need to go away, because if it's not an entitlement, like staff in my department just can't take 20 days of personal leave.
No, but staff in your department haven't had it accruing and sitting and visible to them.
Yes, they do.
And haven't had a practice of it being granted.
Well, they haven't had a practice, but if it's not an entitlement, they shouldn't be accessing it.
Well, is it visible to them? Does it accrue? 20 days personal leave, does it accrue in their...
Yes.
But it's made clear in our Orion system that it is nominal. It is not an entitlement.
And how did you convey this to tribunal members, that it was nominal and not entitlement before it was removed from them?
On the Orion system, it made it clear that it was nominal, and in our pay conditions, as I understand, let me take that on notice though, but it was clear that it was only nominal.
Can you provide on notice how much annual leave was on the books? Or how much of that, sorry, I'll start again. Can you provide on notice, Registrar, how much of that leave, nominal or otherwise, was on the books as at the last day of operation of the ART?
As you know, Senator, I'll make every effort to make that available to you if the information exists.
And Minister, you're not concerned that this decision of the President is causing unrest and grievances in a body that's already overworked? That doesn't concern you?
No, Senator, that wasn't my answer. My answer was that it was a decision of the President, not the government. And the government was very concerned about the state of the AAT when we came to government. That's why we abolished it and created the ART. And we are working with the tribunal to ensure that it is adequately staffed. And we're doing that on a merit-based process, because that is the best way to make sure that we have the right people serving the tribunal.
Yes, but
in fairness to the President, there's an issue here that I would have as Registrar paying people out a leave entitlement that they don't have.
Well, I wasn't asking you about paying them out. I was asking whether or not the leave
Well, it's still
entitlement,
transferring
whether or not the
across. I'm
entitlement would
accruing
transfer
a
across.
non-existent liability.
Well, whether someone gets paid out on termination is a different matter to whether or not, when you transition from one...
But I'm closing the books on one and then transferring that non-existent entitlement into a new tribunal.
Just let me finish, Registrar. Being paid out on leaving an organisation is quite different to having entitlements transfer across as you're being effectively from day one to day two doing the same task, but for a differently badged government agencies. They're quite different things.
Absolutely accept that, Senator,
I was asking you
but at the
about
same time,
that.
I am carrying a liability across that doesn't exist.
Right. Did you have a costing of what that liability was?
No, it's not that. I'll find out for you
Right.
as best I can.
Right. Could I ask about protection matters? And I just want to thank the ART for getting in the most recent annual report. One of the few agencies that has done that.
That was done at the behest of the department, Senator, who encouraged us all to have our reports in to be fully transparent to this committee.
And then they didn't do it themselves, Registrar. Did you know that? Then they didn't do it themselves.
He didn't know that. The Registrar didn't
know that.
that.
Gesta non verba is what you should say to the department. Gesta non verba.
I just wanted to take the opportunity.
Do what I say.
No, Senator. I just want to take the opportunity to thank all my staff for the considerable
Yes.
effort that they put in to have this document prepared in time for this particular Senate
And you
estimates
can
hearing.
tell them that the department that was chasing them didn't do it. But the but be that as it may, can I ask you about? I have a bunch of data I think that's been gathered from annual reports that shows the number of protection matters seems to be increasing significantly, pretty much year on year. Do you have the numbers in front of you, either you or Mr. Zhu, or who has those numbers?
I do. So protection matters, at present, we have 41,449 on hand as at 31 August.
All right. And the numbers
Okay.
I had as at 30 June were 42,764, so it's roughly the same.
Yep.
And I think last financial year there were 19,000 odd lodged and 17,000 finalisations. Is that right?
Sorry, I've got the... Have you got the financial year ones? I've got 14 October to 31st of August, again, being the ART.
I think I got this from your annual
Let me have a
report.
look. 24-25, protection, we had 19,147 lodgements.
And 17,022 finalisations.
17,022 finalisations.
And the year before it had been 12,278.
Yes.
And 11,880.
I think we discussed this just the other day, Senator. Yeah.
And the year before 9,792 and 6,709.
Correct.
And is it true that the medium time to finalise in the 23-24 financial year was 243 weeks?
I don't have that number on me.
Do you have it for the 24-25? The median time to finalise?
I don't have it before me. What I can offer, Senator, is that in the past 18 months, we have focused on the most aged protection cohort, and you can see that in the finalisations in the past 12 months. We had, again, 14 October to 31 August, 16,156 lodgements against 16,145 finalisations. So there's been that focus on the most aged protection cases. And in finalising those most aged cases, some of which have been 6 or 7 years, it has blown out that median time for finalisation that you're referring me to. It's also blown out the median time for finalisations of matters across the tribunal, which I'm sure Senator Scarr would have referred me to had he had more time.
No, but well, my numbers say it was 243 weeks in 23-24. Would that be about right, Mr. Zhu?
Kelvin Zhu, Acting General Manager. The latest statistics is average for protection cases is 206 weeks.
That's average, but
yeah, that's
the more
the
accurate
latest
figure is the median.
It's the average, yeah. Median weeks to finalise. That's from the establishment of ART to the end of August.
206?
206 weeks. But I have to probably mention the average time taken have to be based on the age of the cases we finalized. Some of the cases are more complex as they age.
Yes. Well,
But as I've said, Senator, we've finalised the most aged, which has had an impact upon the median time, because the time for finalisation is obviously taken from the time of lodgement to the time of finalisation.
Yeah. But the median time, if I go back to 2008, 2009 was 12 weeks.
2008?
2008, 2009 was 12 weeks. If I go to 11 and 12, it was 21 weeks. If I go to 2017, 18, it was 31 weeks.
Yep.
And my numbers have the median time last year at 243 weeks, and it was probably longer in the most recent 12 months.
Yeah. But Senator, with those numbers you've given me, can you also give me the lodgement data as well?
Well, yes.
Because we've had that explosion in lodgements in more recent years, since 16, 17.
Well, and the largest explosion was last year.
Yeah,
financial
that's right.
year.
I've got no control over the inputs, Senator.
Registrar, I fully accept that. Have you had the department explain to you why there was that surge of 19,000 lodgements last year? Did it relate to their decision-making and their case-making
Their
decisions?
resourcing. I understand they had significant resourcing, which has facilitated greater decision-making.
You see, so they got significant resourcing. They churned through a bunch of decisions, which was inevitably going to produce thousands of lodgements, additional lodgements with you, and you got no additional resources.
Mm-hmm.
That doesn't work, does it? That ends up with a 243-week median, doesn't it?
No, I think we're getting caught up with the median of these finalisations because we focused on finalising the most aged cases.
Yep.
It's certainly had an impact upon our lodgements, I accept that. But with the funding that the government gave us, 63 million, I think, over 2 years, that was to focus on the most aged cases. And I can say that our members, that cohort of members that focused on that caseload, reduced the 3-year plus cohort of cases by 53%.
So if someone was filing a protection or lodging a protection application with the ART now, when could they expect it to be decided?
At the rates we're finalising now, I would expect within 3 years, because by the end of this year, Senator, I'm anticipating that we will have no protection cases in that plus 3-year cohort at all.
All right, so that's still like an extraordinarily long period of time to wait.
It is,
3
Senator.
years.
Yeah, look, I accept that. You know I worked in that caseload myself. We have 10% on average of people who have lodged a protection visa, probably entitled to that protection visa. But in order to get to that percent, we've got to go through the other 90% as well.
Yeah, indeed. And you can't help the quality of decisions that are being made in the department. You're a customer of good or bad decisions that have been made in the department.
We get inputs, Senator.
Yeah, indeed. Have you seen any changes in the proportion of matters that are being reviewed and sent back for reconsideration?
I'm not aware of any change in pattern. It's still around the 10% margin.
Can you provide those numbers over the last 4 financial years?
Last 4 financial years?
Yes.
I can do that for you.
And the 115 FTE shortfall that you have, is that having an impact on your timeliness of protection matters?
Sure. It does. So we've been funded to renew or reappoint that 85 FTE, and as I said, that 85 FTE have been appointed for 3 years, funded for 2, but that funded 85 FTE will finalise 36,000 of these aged cases.
Yep.
The members appointed pursuant to what I call our funding model, our BAU, will be approaching the front end of the caseload as they come in.
Have you done any review of whether or not the provision or otherwise of legal assistance to protection matters hastens or not you're dealing with matters?
No, I've got no information on that.
Have you had any anecdotal reports from tribunal members about the benefit of people being legally represented?
It's certainly nice to have them represented. I can speak from my own experience.
Does it make matters normally quicker and to deal with because issues tend to narrow and you focus on the core issues?
I'm not certain of that, Senator, to be honest.
Right. Okay, thanks.
Thank you very much, Senator Shoebridge. Pending no more surprise questions from the end of the table, which is probably my fault, we're now in a position to release the Administrative Review Tribunal. Thank you very much for your time this evening.
Thank you, Senators.
We'll suspend for a very, very short break while we welcome resume. I understand we've got a number of questions from Senator Scarr that will take us to 10:15 this evening, which means that we will not get to the Office of the Australian Information Commissioner or the Anti-Slavery Commission. We'll now go to Senator Scarr for questions. Thank you very much.
Thank you very much, and good to see you again, Mr Pringle. And you've got the Minister at the table who you're used to seeing on the other side of the room. But we're all together again.
Which we've managed to do tonight, haven't we, Senator Scarr?
We have. Mr Pringle, have you had an opportunity to review the review document, the review of the operation of the Federal Circuit and Family Court of Australia Act 2021, the report to the Attorney-General, and do you have any observations in relation to that?
I have, Senator, and it was some time ago, so, and I'm conscious of time, obviously, in terms of the nature of it, is a quite detailed document, but in broad terms, the courts consider that it was a very positive review of the operation and leadership of the courts. The positive nature of the comments were encapsulated in a press release by the Chief Justice after the report was released and cover significant comments in relation to family law, general federal law and migration, all of which were in broad terms seen as being very positively dealt with by the courts.
Well, that's certainly how I interpreted it, and to the courts and to the leadership of the court as well. And that includes you, Mr Pringle. So congratulations to you, and your team at registrars are commented on very favourably as well, I note in the report. Minister, does the government share that review, that view of the review, that it was a positive review with respect to the reform?
Well, the review was completed and tabled and was welcomed by the Chief Justice of the Federal Circuit and Family Court. It's under consideration by government.
So the government hasn't reached a view yet as to whether or not it was a positive review or not?
There's a table on the 7th of August, Senator Scarr.
So the government doesn't have any view as to whether or not it was a positive review?
It's under consideration, Senator.
It's under consideration, yeah. Right, okay. Well, just walking through some of the key points, Mr Pringle, the review talked about enhanced collegiality and cooperation. and I'll just quote in that regard. Alongside these descriptions of a changed workplace were frequent references to improved judicial wellbeing, often attributed to the reduced docket sizes of judges in the new court, especially Division 2. Does that reflect your views as the Chief Executive Officer and the Principal Registrar?
Yes, indeed, Senator. At the time the reforms were implemented, the average docket size of Division 2 judges was in the order of 330 plus. They are currently about 68, and that means a lot of pressure has come off. Judges who are very hard working have to deal with the really complex cases.
Excellent. I was particularly interested in paragraph 8.39, especially given the former Attorney General's quite inflammatory comments in relation to the reform when it was first introduced. I want to quote, "As to the family law appellate jurisdiction, despite much conjecture before the reforms, overall the changes appear to have been well received. It was recognised that the timeline of appeals has greatly improved." End quote. Again, is that your experience as the Chief Executive Officer and Principal Registrar?
Indeed, the appellate arm of the court has been doing exceptionally well. I think, if I'm not mistaken, there wouldn't be an appeal older than 3 months in the courts. I'll correct myself later if I'm wrong about that, but that's been a very solid arm of the court for some time.
Okay. There is a remark in relation to section 50 of the Act in the review document, and but it is referred to in the context of, generally speaking, the courts have supported the single point of entry and help as helping promote clarity and certainty. Do you have any additional comments you can provide with respect to section 50 in particular?
They're matters that really relate to original jurisdiction, and there's case law on it. The courts have engaged with government about that issue, but ultimately that recommendation that covers section 50, like the other two recommendations, are a matter for government. And of course the courts would facilitate and cooperate with government in terms of dealing with those issues.
Okay. 8.65, the reviewers, and I quote, heard strong praise for recent innovations by the court, Division 2, including the development of the central migration docket and for the leadership of the court, end quote. What was the history with respect to the introduction of the central migration docket?
That is a system which, instead of having matters sitting in judges' dockets, very large numbers given the high volumes of filings in migration, they're all centralised, and then they can be triaged, assessed, tagged for characteristics, and then docketed to either registrars or judges in a very effective and efficient way. That's been an evolutionary process and has really come into its own, in particular since the Federal Circuit and Family Court has taken over management of its own migration jurisdiction since last year.
Excellent. Paragraph 8.66, which is entitled "A Calmer Family Law System," the reviewers found, and I quote, "The prevailing impression conveyed by the consultations for this review is that the aims of the court reforms have been largely successful. This is particularly so for the dual leadership appointments for the courts, the single point of entry for the family law matters, the new appeal processes, and the specialisation requirements for appointment as a family law judicial officer," end quote. Does that reflect the experience you have as a leader of the court, as Principal Registrar?
It does, both internally and externally. I think the report actually comments on how the profession and other external users have seen the courts operating as effectively and efficiently as they have for a long time.
Excellent. So if I can just take this opportunity to congratulate the Chief Justice, yourself, Principal Registrar, and your team for what has been an extraordinarily successful reform. Thank you very much.
Thank you, Senator.
Thank you, Senator Scarr, for seeing us out for the evening.
Thank you.
Appreciate that. Thank you very much for your attendance here tonight. That concludes today's proceedings. I thank ministers and departmental officers for their attendance, as well as Hansard Broadcasting and the Secretariat for all their assistance in making today happen. I'll say thank you to Senator Cox for moving the acceptance of documents tabled throughout today's proceedings. And I also remind senators that written questions on notice should be lodged with the Secretariat by 5 p.m. Thursday the 16th of October. This hearing is adjourned. Thank you very much.